Yes. Application? Yes.
Lord, bring for inclusion in the list of a CAN application.
My Lord, may I mention one matter, my Lord, pertaining to first miscellaneous appeal. My Lord, it was defective due to a delay of 4 days. Yesterday, the matter came up, and your Lordship, and the CAN was not filed yesterday, but it was eventually filed, and today your Lordship directed
Appeal
the
is
matter to.
appearing in the list.
My Lord, the appeal is appearing in the list. Your Lordship directed the matter to appear today.
Yes, it will
Today
appear
it
along with
intact,
it.
my Lord.
Right.
My lord,
Wait.
there was a delay in depositing the special messenger cost unless it is found
mentioned.
to be mentioned.
Done. In view of the above findings, FMET ARB Award number 47 of 2023 is allowed on contest, thereby setting aside the impugned order bearing order number such and such, and allowing the application under section 34 of the 1996 Act by setting aside the award dated September 21, 2011 passed by the West Bengal Micro such and such Council in case number 170 of 2010 on the ground that the said award is vitiated by utter lack of reasons and due to non-compliance of section 18 of the 2006 Act, as well as the proposition laid down in Jharkhand Urja, the citation. No order as to cost. Connected applications, if any, stand disposed of. Interim orders, if any, stand vacated. The point regarding limitation, the main claim being barred by limitation, we have discussed but kept open. That's why you have clarified in our order that the award is set aside on the grounds of lack of reasons and non-compliance of section 8.
But only one thing, Milord, we had put in some money, Milord, for our 34 application to be heard. Now, Milord, 34 is allowed. So, Milord, we are entitled to, Milord, get that back.
Under the Act, are you entitled to get that back?
Yes, yes.
It's there in the Act. Just, are you sure? If you are sure, then we'll.
But kindly allow us to put in necessary application before the court, Milord. Milord will do that if we can
We have
satisfy.
done it. Acha, very well. After the above judgment is passed, it has later will add. After the above judgment is passed, comma, learned counsel appearing for the appellant points out that the appellant may be permitted to apply before the court taking up the section 47, section 34 application for withdrawal of the deposit of 75%, which was made before the said court. First up, next para, leave is granted to the appellant to make such application before the aforesaid court, subject to the said court deciding on the application in accordance with law.
Deeply obliged, my lord.
এটা এখন সই করছি না, তাহলে লেটারটা অ্যাড করে তারপর অ্যাকশন সই করব।
Grateful.
Thanks.
Yesterday, Lordship has disposed of this matter.
Yes, we repeatedly asked them whether it has been disposed of. They said that no, it has not been disposed of. It was previously disposed of. কোন অর্ডারটা ডিসপোজ অফ হয়েছিল? এই যে দেখাতে বলেছিলাম না, অর্ডারটা রেডি করে রাখতে হতো। Yes. In our order dated July 7, 2025, comma, we had disposed of CAN 2 of 2018 within bracket old CAN 2056 of 2018. Next para, however, comma, we find that by the order dated August 19, 2021, comma, the said application had already been dismissed. Thus, comma, without any application for restoration of the same, comma, the order dated July 7, 2025 is modified to the extent insofar as it pertains to CAN 2 of 2018. However, comma, it is made clear that the rest of the order dated July 7, 2025 shall subsist.
Great.
Thanks. Only that portion we have taken out.
Well, this matter has come at my instance.
Yes, Ms. Sharma.
This is well, we have the plaintiff's appellants. The suit for partition was directed against an order on rejecting an application for temporary injunction only on the ground not non-joiner of necessary parties and other joint properties not included in the plaint. And that appeal was admitted. An injunction was there. But my injunction application was disposed of. But they are constructing. We are now landlocked. My client.
You had challenged an ad interim refusal.
No, temporary injunction. Rejected.
In this court, you are enjoying an interim order.
Yes, yes, yes.
I am for the respondent.
No, wait.
There is an order, division bench of this honorable court, that appeal and application should be heard analogously within 2 weeks. This is the year 2021. At that time, COVID was this is the order.
So what is your prayer now?
My lord, your lordship kindly, my lord, because my lord, my client is a landlord, they're blocking the fencing and
Then you
constructing.
file a proper application for implementation or contempt.
No, my lord, application was there, 2 of 21. 2
That
of
was
21.
injunction.
Yes. Implementation of the order. My lord, we made an application for
So that order, you should have mentioned that application. We'll
That
take up that application.
Yes, 2 can. Well, I have already 2 cans, 2 of 2021.
Can 2 of 2020 will place in the list and dispose of?
Yes.
Why has to be mentioned?
Yes.
There is an order.
Huh?
What the appeal?
No, আসছে না বলছে।
Keep pending নেই। No, need not now. When you take up, we will place the application. You make a
My lord, the suit which was filed by my client is dismissed.
suit has been dismissed.
Yes.
This has become infructuous.
10 January 2023.
But we will direct the application to come tomorrow. No, not tomorrow. We'll keep it on Monday. And you please bring the copy of the order whereby the suit was dismissed.
My client sent the order by mobile.
It is right now there.
Yes.
No, not like that. Give a printout to them also.
Instruction, my lord.
Then we'll keep it in the list tomorrow. If you are ready with that order, give a copy to them.
Tomorrow I'll
Learned counsel appearing for the appellant submits that.
My lord, কালকে, my lord, I'm sorry that some resolution has been passed, my lord. Your lordship,
For what? Why?
There is the one regarding the that is the reason
No, resolution for what?
there is a order gone tomorrow. That is the reason, my lord, maybe, my lord, there that is
Oh, you come.
Day after tomorrow. Your
How they called by?
that I do not know. I have heard here.
Any
Mother,
party
day
having
after
any influence in our state?
Yes, the bank is closed. The post.
Oh, our state, in our state.
my lord, day after tomorrow.
Let it appear tomorrow. If both of you are not there, we will not take up. But
As I-
try to be there online at least then. Ms. Sharkar is very online savvy, so she'll be.
Tomorrow or day after tomorrow, your lordship.
Day after tomorrow. Learned counsel for the appellant submits that the respondents are violating the order of injunction passed by this court. Full stop. An application for implementation of the said order bearing Can 2 of 2021 has already been filed. Full stop. Next para. Learned counsel for the respondent submits that in the meantime the main suit, comma, from which the present appeal arises, comma, was dismissed. Full stop. Next. Dismissed for non-prosecution. Full stop. Next para.
জানি না কি।
Be that as it may, comma, let Can 2 of 2021 be listed under the appropriate heading for hearing on July. Day after tomorrow, we take up appeals. Then on Monday,
Monday.
on July 14, 2025.
Yes.
First,
I'm good.
July 14th, application task. When you take up the application, you please just hand over printout of that.
Yes.
Next.
I'm grateful to Lordship. I have no instruction.
Yes. Why is it appearing as to be mentioned? Oh, that child. We will pass that order. We indicate it to you. You did not give your name to our officer, so it's come as anyway. We had an interaction with the child. What is the name of the child? We have forgotten. He told us, but it's my fault. বললো ইশাক নাকি বললো জাস্ট ভুলে গেলাম
সাকিবুল হোসেন বিশ্বাস
সাকিবুল
সাকিবুল
SAQIBUL
AKIBUL
আচ্ছা
then HOACL
we had an interaction with the minor child Shakibul yesterday in our chambers. Pushed up. It was the child came across as an intelligent young man in the making. Pushed up. Next para. Upon hearing the child, comma, it appeared evident to us that due to the long alienation between the child and his father, comma, the child is apprehensive of meeting his father, comma, since, comma, in his perception, comma, the appellant father is a stranger to him. Full stop. For the, however, comma, since the very alienation perception in the mind of the child justifies that there should be some interaction between the father and the child, and also keeping in view the broader purpose of paramount welfare of the child, which cannot be achieved without the child knowing both his parents, comma, we are of the opinion that a limited visitation right should be given to the appellant father in respect of the child for the time being to explore the possibilities of reconnaissance between father and child. Full stop. Next para. Accordingly, we direct the respondent mother to take the child. The name of the park. Child told that he'll yes. The child told that he'll give the name of the park. Mr. Chatterjee, your client has to take the trouble to go there.
Mohua Songo Club. My lord, it is Mohua Songo Club, my lord.
Mohua?
The address. Mohua Songo Club.
Very well. Write it on a slip of paper. Accordingly, we direct the respondent mother to take the child to Mohua Songho Park, a park in the vicinity of the present residence of the child and the mother, on every alternative Sunday at 5 p.m. Full stop. The first such visitation shall be on July 13, 2025. Full stop. Next para. Such after taking the child there and leaving the child with the appellant father, the mother shall stay outside the precincts of the park for 2 hours between 5 p.m. and 7 p.m. Full stop. During the said period, the father shall have an interaction with the child. Full stop. Next para. Immediately upon the expiry of the said time period, the father will hand over the child to the mother. Full stop. Next para. Such visitation shall go on until further orders. Full stop. Next para. The application shall next be listed in the monthly list of September 2025 for passing further orders. The parties shall act on the server copy of this order without insisting upon prior production of a certified copy. Thank you. Arekta line add koda, it is made clear that in the event there is any difficulty on the part of either of the parties or the child in such visitation, leave is granted to the parties to mention the matter for inclusion in the list for earlier than the returnable date. Thank you so much. Actor line prothome diye diye affidavit of service filed to be kept on.
Please, your lordship.
Yes.
5 and 6, my lord, I'm being led by Mr. Jishnu Shaha, my lord. He's on his way, my lord.
Pardon?
I appear for the respondent award holder, my lord. I'm being led by Mr. Jishnu Shaha. He's on his way, my lord. My lord,
Yes.
the appellant can
His arguments was concluded on the
No, I was to start, my lord. I'm being led by
start.
Mr.
Yes, yes,
Mr.
right.
Suman Kumar Dutt, my lord. My lord, I am starting, my lord. Kindly, my lord, permit Mr. Suman Dutt to later take over when he comes.
Absolutely. You are Mr. Chattopadhyay or Mr. Sinha?
Mr. Sinha, my lord.
এগুলো সব ভলিউম পেপার বুকে Which volumes should you require first?
SMA 939, part
Which
1 and
volumes
part
of the paper book should you require first?
Part 1 and part 2, my lord, both, my lord. I'll start
Not the
with
supplementary one.
supplementary, my lord, some documents which form record of the tribunal, my lord, were not included in
So
the
right
report,
now
my
we'll
lord.
take up part 1 and part 2
Yes, my lord.
for the time
Part
being.
2 for the time being, my lord, first.
Part 2.
Part 2.
ওগুলো ওখানেই থাক, part 2 টা আমাদের। Yes.
939. Now, my lord, although these matters are appearing analogously, my lord, but the contracts are different, the arbitrators are same, there are 2 separate awards, and the section 34 codes are also different, my lord. But they were
The doctor is also the same in both. I said, no, viewers. So, but those were heard together by this
the arbitration was held together, my lord, but the codes were different, 34 codes were different. And the
awards are different order.
Awards are different.
Not copy paste.
No, it is copy paste, my lord. At the end, that is what we say, my lord, there has been really total non-application of mine on part of the arbitrators, my lord. Two separate contracts, the same logic and reasoning goes for both of them.
But if the German clauses were the same, then what
The
is the
German clauses were not exactly same, my lord.
Correct.
Some difference was there. These, now, my lord, may I start, my lord?
Yes.
May I start with the
Mr. Basu, you want to mention something?
Item number 8, 9 chain, my lord. The other 11 appeals were heard, my lord, in pursuance of.
Yes, we remember.
Lord, there is a defective, the note says, my lord, it is a defective because barred by limitations. But the fact is otherwise. Supreme Court condoned the delay.
So you point it out when it is taken up. You point out when it is taken up. Any other defect, Mr. Basu? Sorry. Yes. Yes, Mr. Sena.
Now, my lord, kindly takes up page.
Do you like to start or Mr.
He's coming, my lord. He's just having a glass of water, my lord. He's on it. I'll just
Yes.
place the contract, my lord, first, my lord.
Please.
Now, kindly takes up page 16 of the second part, my lord. That is where the contract is. It's a very short contract, my lord. I'll just place.
So we are taking up page 16 of part 2
2.
of FMA 939.
39, my lord. For
Right.
the first matter. Yes, my lord, I'm starting. It starts, my lord, this memorandum of understanding, it is at Kolkata, West Bengal.
It's a bit illegible.
It is a bit illegible.
First
my lord.
page. Yes. Anyway.
On 11th of March 2004, my lord. Then the parties here, my lord, the Odisha Mineral Development Company Limited, that is my client, my lord, of one part, my lord, and the second part is, lordship, it's illegible, Shri Ramrupai Balaji Steels Limited. Now, my lord, this is the respondent, my lord. This company is now, my lord, Jai Balaji Industries Limited, my lord. Now, my lord, at the bottom, my lord, and whereas OMDC is into the mining business of iron ore, having mines in Odisha and are mining iron ore and selling the same to the prospective buyers. And whereas SRBSL is the manufacturer of pig iron, for which basic raw material is iron ore, hence SRBSL has approached OMDC for entering into a long-term supply contract for fulfilling their requirement. Then, my lord, so, my lord, OMDC, my lord, is engaged in the business of mining of iron ore, my lord, and SRBSL.
You are OMDC?
OMDC, my lord. I mine iron ore, my lord.
Very good.
And SRBSL, they manufacture pig iron, so, my lord, say require iron ore as a basic raw material, my lord. Now, kindly takes up the next clause, my lord, that is after clause number 4, my lord. And whereas OMDC has agreed to provide 7,000 metric ton of sponge grade calibrated iron ore of 65% Fe 518, 5 to 18 millimeter per month of SRBSL under the following terms and conditions, subject to availability of the same. Now, my lord, this part is important, my lord. Here it is 7,000 metric ton of sponge grade calibrated iron ore. Then this is the grade, my lord, 65 Fe 518 millimeter per month of SRBSL to under the following terms and conditions, and then, my lord, subject to availability of the same. So only it is available, my lord, then this supply is going to be made. Now, my lord, kindly takes up next is, my lord, that the SRBSL shall abide by all the commercial terms of OMDC prevailing at the time of lifting of the materials. Then SRBSL will participate in the tender called by OMDC, will try to be the highest bidder, failing which OMDC may provide 7,000 tons of sponge grade calibrated iron ore of 65% Fe 518 millimeter per month to SRBSL, subject to acceptance of SRBSL to procure the materials at the price and other terms and conditions.
Was there a tender and they became the highest bidder?
No, my lord. I'll tell you, my lord.
Therefore, this clause will come into force.
This will come into
not the
play.
previous one.
No, but I'll tell you what happens, my lord. 7,000 metric ton would have been supplied had there been first surplus of quantity, my lord. Yes. Now, my lord, if they participate in the tender, then this is guaranteed. If they don't participate, if they may provide, my lord, it clearly says, subject to a sponge grade iron ore. I read the clause once again. The SRBSL will participate in the tender called by OMDC and will try to be the highest bidder, failing which OMDC may provide. Then, my lord, per month, subject to acceptance of.
Oh, if they fail in that or do not participate, then the price and the other conditions will be governed by the highest the highest bidder has.
Yes, my lord. But this 7,000 metric tons only if they don't participate, only if they have surplus. It says may, there is no contractual obligation that 7,000 metric tons will have to be supplied if they don't participate. Now, my lord, kindly takes with B, my lord, clause D also, my lord, this is connected, that SRBSL, if it becomes the highest bidder, OMDC may provide additional quantity over and above the committed quantity as indicated in clause 5B.
This is not applicable.
Then
They have not become the highest bidder. They did not participate at all,
It only shows that 7,000 is the maximum limit they can get per month.
if
they don't-
available.
If available, if they don't participate. If they participate and becomes the highest bidder, then in that event, Millard, they may get more. Now, Millard, may I just indicate one or two more clauses, Millard, the same clauses. Millard, kindly mark these because it will be relevant.
Hmm.
I am obliged to give him 7,000 metric ton per month. So,
Yes.
So this per month has, my lord, will have some significance when I come to the award.
All right. So there are two riders. One may, as per 5B, and subject to availability, as per clause 4.
And the important thing is upon 100% advance payment. Kindly, my lord, see the language.
Shall.
And that is what the parties understood. See that SRBSL shall make 100% payment in advance before lifting the materials. Now, thereafter, my lord, if your lordship turns over, OMDC shall have the right to give the contracted material to any other party if SRBSL, let's take it, my lord, the claimant, fails to lift the materials at the highest bidder price. OMDC shall provide 7 lakh metric tons of sponge grade charge and such per month from 1st April during the tenure of the contract. The tenure of the contract, Mirror, is the tenure of the agreement shall be valid for 1 year commencing from 1st April 2004 and will be renewed for a further period solely at the option of OMDC on terms and conditions as may be mutually agreed to. The contract renewal can be terminated by either of the parties by survey. Now, Mirror, the period of 1 year was never extended. So we are concerned with the period, Millard, from 1st April 2004 to 1st April 2000 or 31st March 2005.
Yes.
Now, Millard, I will just show the 4 letters which was the only evidence before the 4 or 5 letters.
We'll take up the supplementary paper book for that.
No, it's part of
this one.
So, Millard, if I may understand the contract, because my reading of the award is, Millard, the entire contract has been turned on its head. My understanding of the contract was that if you are not a highest bidder and I have surplus, then in that event, upon payment of 100% in advance, you will be entitled to lift. So there are 3 obligations on his part. One, he has to apply. He has to deposit 100% and then take a permission to lift the materials from wherever the materials are lying. Sequence of facts, as I'll show, Millard, is this. April, May and June. Because, Millard, the reason why it is taken in quarterly fashion, because tenders are being floated. At that point of time, tenders were floated on a quarterly basis. April, May and June, I make a supply without insisting on 100% payment. I have made a supply. From June, July, August, September, October, November, there is no correspondence. 7 except 2 letters, which the arbitrator has said that, which will show that he was intending to lift. But the arbitrator does not say that this intention to lift materials was coupled with the advance payment of 100%. In December, 28th of December, if I am not wrong, comes the first letter that the supply that I have taken in the month of April, May and June, I am concluding the payment now. So in December, they go and make final payment of the materials which they got supplying. And when they ask for additional payment, I say no. You first make 100% payment.
Yes.
Thereafter, you will be entitled to lift because that is the term. Then on one day before the contract expires on 31st, they gave me a check, post-dated check of 25 lakhs each, undated checks with the added rider that please fill up the checks only when I advise.
Checks for in lieu of what? For what?
They said it was a check made ad hoc because I could not, if I add up the checks, they come to 2.25 lakhs. The amount for which they could have got the supply at the rate, Miller, doesn't tally up to that. So it was an ad hoc payment.
As per them, as per their letters, those payments are for what?
These payments are for
lifting.
supply.
For the supply.
But these were not payments. They were checks given with the condition.
rider.
Yeah. So they were not 100% payment. If I give a check that don't present it, that doesn't tantamount to payment. And the contract expires. Once the contract expires, when they again apply, I say no. You participate in the tender or else. Now, this 3 months, which Millard I had made payment, their submission was before the arbitrator, not in pleadings, that since I have supplied the initial 3 months without insisting on 100% payment, I have waived. I have waived that condition. For argument's sake, the tribunal takes that to be a waiver of the entire contractual period. On the teeth of a letter, which says that I am not going to henceforth make any payment. I told you, Lordship, March, April, May, June, I had made. From June to November, there is nothing. In December, when he pays the 3 months dues and asks for further, I say no, you pay 100%. So even if there is a waiver, I have now put down my foot during the continuance and said, no, you can't do it. The arbitrators proceeded on the basis that once you have waived in April, May, and June, that constitutes a waiver during the entire length and breadth of the contract. Which, Millard, in my respectful submission, probably may not be correct because we are now, Millard, we are governed with the pre-2015 award. Number one. Number two, the second claim that was made was that during that first period of April, May, and June, you had supplied me defective goods. But the arbitrators came to the conclusion that you have ultimately made payment for the same and you have consumed it. So that claim was rejected. The third claim is they say from June till November, they had to procure a portion of the materials from the market at a higher price and therefore the difference. So they have mitigated their losses. And the arbitrator says you are entitled to pay this amount because the sole thing is that you are in breach. Why? Because you could not have insisted on 100% payment.
Loss for what? They loss for non-supply.
Yes. They say that I had to procure. That was another point.
They had to procure from another.
I have procured, but there is no evidence that from June till October, for this period when you procured, you had applied or you had made payment and I have said I will not supply. There is no evidence. But the arbitrator proceeds on the basis that since that 100% payment clause has been waived once, therefore it is now your obligation, whether they apply or don't apply, you have to go on supplying it. That, Millard, probably is not the intent of this contract, if I can understand. So therefore that period. And Millard, so far as loss of profit is concerned, is for the balance period where he says that I had purchase orders outstanding and therefore he has suffered a loss of profit. Now, surprisingly, Millard, the arbitrator, while calculating loss of profit, relies upon documents which are purchase orders, which Millard, we usually take purchase orders without the evidence of the person who has issued the purchase order. So, Millard, these are, Millard, the two claims which have been allowed. One is, Millard, loss of profit, and one is, Millard, damages. Goodwill and loss of goodwill and defective products have been disallowed.
No, defective product, that has not been.
That's Millard, one thing is very important which struck me is, Millard, it's now well settled that if you are pleading a case of waiver, you have to plead it. This cause of action to plead waiver arose prior to the disputes being had arisen. Because I told your Lordship, Millard, that in December for the first time after May or June, they applied. When I said that you have to pay 100% payment. And the statement of claim was filed thereafter. So, Millard, my learned friend's clients or the claimant was aware of the fact that we are insisting on a term of the contract, which according to him was waived. So, this is a cause of action which has arisen prior to that. Now, Millard, if you are hurriedly, Millard, if I just take your Lordship to 4 paragraphs of the
Waiver was not pleaded according to you. Yes.
Millard, paragraph.
Which page and which volume, sir?
Millard, it would be part 2.
Yes.
But Millard, the part 2 starts with page 1.
Yes.
That's the problem.
Has to start with page 1.
Part 2.
Has to start with page 1.
But Millard, this is not the usual paper, Millard. It is a continuation.
So, so you are placing what?
I am placing the Millard part 2, the handwritten. I am placing 4 paragraphs from the statement of claim.
Statement of claim. Yes.
Millard, kindly come to paragraph 10 straight away, which is at page 4.
Yes.
Accordingly, in the month of March 2004, at the office of the chairman cum managing respondent, it was agreed by and between the representative, the claimant on the one hand, and the chairman and managing on the other, for purchasing sponge grade calibrated iron, so and so the claimant might participate in the tender to be floated by the respondent. However, in the event the claimant does not participate in the tender and by participating in the tender fails to become the highest bidder, then also the respondent would supply to the claimant 7,000 metric ton of sponge grade iron per month for the period of 1 year commencing from 1st April at the price and other terms and conditions accepted by the highest bidder in such and such. On the basis of this understanding, paragraph 11, on the basis of the terms and conditions agreed by and between the representatives of the claimant and the chairman and director of the respondent, a memorandum of understanding was executed by and between the parties on 11 March 2004, a copy whereof is marked A. Now, paragraph 12, Millard, he says that I was obliged to supply, Millard, in these 4 quarters, April to June, July to September, October to December, and January to March. These are the 4 quarters. Now, the rates have also been given, but the reason why I said, because the last payment does not match with these rates. So that was add-on. Now, how did the parties perform? Paragraph 14. During the month of April, May, and June, the respondent supplied so and so, so and so, and so and so, all below 7,000 metric ton. Kindly make a note. Respectively, of sponge iron of 60 by at a price of 1915 per metric ton. The claimant lifted such and such of sponge iron during the month of April, May, and June, respectively, for various mines depots. Respondent at Odisha making full payments therefore.
This was made later, not after making payments is not correct. All right.
Unfortunately, out of the quantity of 13557 of sponge iron of 6 such and such, supplied by the respondent, the claimant during the period April, May and June, during the period April, May and June, let it be lifted around 2290 was of inferior quality.
This has not been allowed.
Then, as per the usual practice, paragraph 19.
Yes.
Or Millard starts from 18. After the month of June 2004, the respondent failed and or neglected to supply any iron ore under the memorandum of understanding dated 11 March 2004 to the claimant. As per the usual practice, the claimant went on sending undated checks of 25 lakhs each to the respondent with the request that after issuance of necessary delivery orders, the dates on the check should be filled up and presented for encashment upon prior notice to the claimant. These checks, my lord, subject to correction, was sent to me sometimes in January 2005. Right, sir?
Do you get it from any
Evidence, all
correspondence?
letters, all letters. Oh, that's the reason I'm taking it. Reminders were given by the claimant to the respondent to resume supply in as much as there was an acute shortage of such and such iron ore at the plant for which the claimant was suffering.
Nothing in writing before December.
Two letters, one June, one October, which doesn't say anything. Now, Millard, this 70422, Millard, has a basis, Millard. And I indicate if it's 7,000 metric ton per month, which he says, if your lordship multiplies into 12, it comes to 84,000. He has received 13,557. The balance is 70443, the entire amount. So, my learned friend is proceeding on the statement of claim proceeds on the basis that it is not a monthly supply. It is an ad hoc supply. I have agreed to purchase an entire quantum of iron ore and I can take it in whatever manner I find. That is probably not the contract, but the arbitrator has held it that way. Then, Millard, undated checks were returned. Kindly see, Millard, this is important, paragraph 22. In the month of December 2004, a meeting took place by and between the representatives of the claimant on the hand and chairman and managing the respondent or other at the office of the respondent, wherein it was agreed that the quantity that had not been supplied under the memorandum of understanding dated 11th March 2004 till December 2004, this is this period, should be supplied during the period January 2005 to March 2005. The representatives of the claimant were assured by the chairman and managing the respondent that by 31st March 2005, the entire balance quantity of 70442 would be supplied by the respondent to the claimant. Now, at this oral agreement, which my learned
Any meeting minutes?
But the arbitrator has proceeded on the basis that my obligation was to supply irrespective of any payment, and I have gone. So, in spite of writing letters in the month of December 2004 regarding discussions that took place between the parties that the normal supply would be resumed and the entire balance quantity of such and such would be supplied by the end of 31st March, there was no response from the respondent. In about March 2005, the claimant was shocked to receive a letter of 15th March from so-and-so. Since the claimant did not participate in the tender, the question of supplying any material to the respondent does not arise. Thereafter, respondent under cover of 29th March, this is one day before the contract expires, purportedly returned back to the claimant the undated checks of 20 each aggregating 25 lakh each aggregating to 3 crores. Now, this 3 crores payment has two parts. 75 lakhs was in respect of the other contract and 2.25 was in respect of this contract.
Other contract means?
The other arbitration, where other. But the tribunal proceeds on the basis that since 3 crores was given to you and you had the money, So you could have easily supplied. So it's not a case that he was not made payment.
The other contracts terms are similar.
Millard,
Differences are-
no, Millard, the terms are not that similar. Then Millard, so this was Millard the case. His case now starts, Millard, from paragraph 25. This is the facts. Under memorandum of understanding of such and such was obliged to supply an aggregate of 84,000, which I indicated to your lordship, a sponge iron. After supplying 13,557 sponge grade iron for the months of April to June, the respondent failed or neglected or refused to supply the balance quantity of 70442. That's the other amount of sponge grade iron of 60. Inasmuch as the claimant required sponge grade elevated iron, then this is not required. In spite of endeavor, could not procure. Then Millard failure with costs. What I'm trying to show is, Millard, there is no indication of any waiver. Although, Millard, the letter pursuant to which, Millard, I had insisted on payment is what has been referred to in the claim. And Millard, now the claims, Millard, of which, Millard, page 12, A was allowed, B was rejected, C was allowed to the paisa. And T was disallowed.
The ABC were allowed.
A was allowed,
A.
B was disallowed, C was allowed, D was disallowed.
Good.
So A and C.
Yes.
Now, Millard, only 4 or 5 letters, which the tribunal has also taken note of, and I also have made sort of stuff. সব ঠিকঠাক লিখেছিস? বিষ্ণুদাকে একটা কপি দিতে হবে। বিষ্ণু, list of dates. Millard, that is a list of dates, Millard, for your lordship's convenience. Your lordship, that would take time, Millard. I'll go.
Yes.
It'll be faster if I go by the letters.
Yes.
But that's, Millard, the entire list of dates. Millard, kindly, Millard, first come to 2 letters. One is at page 20.
May I have your lordship's leave for a few minutes?
Pardon?
May I have your lordship's leave for a few
Yes, yes, absolutely. Yes.
Millard, this is 29 June. Millard, I'm trying to concentrate on the period from June to December.
Right.
This is in continuation to our earlier letter wherein we had highlighted the poor quality of iron ore received by us. We have received 2 more consignments, such and such dated 6/2004, and we are sorry to write to you that the entire lot is unfit for use, and we are hearing giving report of analysis of the work done. Then Millard, lordship will ignore it because this claim was disallowed. Last paragraph, service analysis of is also being carried out for this consignment, and the details will be intimated to you shortly. On the first eye inspection under size material, 30% oversize not necessary. What is necessary is, Millard, the last paragraph.
Yes.
We request you to kindly conduct.
So that is also not allowed.
No, last line. If such quality is to be received by us, we are sorry to state we will have no other option than to take alternate arrangements for iron ore. So January, February, March, a dispute arose as it appears, Millard, not January, February, March, April, May. The dispute arose as regards the quality. And this is the only letter that you lordship will find in June. It has nothing to do with further supplies from June to December. Then, Millard, the other letter which your lordship as the arbitrators have also relied upon is at page 44.
Yes. But
This, my lord, your lordship will find within that span, October.
yes.
Kindly refer to the MOU of ours with you regarding the above, and you wish to confirm that the present rate is acceptable to us. So, my lord, he also knows that the rate that the highest bidder has got for that quarter, he has to match. You are requested to advise your minds to raise indents so that we can get materials in line with the MOU. My lord, two things are very important from this letter. One is the obligation to procure is on my learned friend because he has to first match under the contract. If your lordship sees the obligations in line, he has to match. And thereafter, my lord, he will have to pay 100%. And if there is an availability, then this is indents were required to be raised. So, my lord, prior to every supply, there was a process that was required to be followed. Because the reason why I'm saying so, because the arbitrator proceeds on the basis that no process was required to be followed. As if it was my obligation to go on supplying without insisting on the terms of the contract. So, my lord, this will show an indication and evidence coming from the claimant itself that there was a process. The process was that he has to match, which is in terms of the contract. Here he says, I am now ready to match in October, but he doesn't make 100% payment. There he defaults. And the process is indicated that once he makes this, then my obligation arises to raise indents. So these three things will appear from this letter. Thereafter, my lord, kindly come to page 45. Please refer to a letter of 4th December 2004 and subsequent discussions at your office on 23rd December 2004 on the above subject. It is to inform you that supplies can be resumed under the following terms. This is my lord, my letter. I am resuming supply under the following terms. Balance payment of 48,17,369, which is still outstanding against earlier supplies immediately. That is, my lord, for April, May, June. That was my first condition. As per terms, 100% advance payment is to be made before placing indents for future supplies. So, my lord, I have now made it very clear that there is no waiver. Hence, you are requested to release the above payment at your earliest to enable us to supply the materials. This is the letter, my lord, which the arbitrator, I'll show, my lord, how he has dealt with it. Thereafter, my lord, page 46. This is 30th December. We have received your letter on the subject and are pleased to enclose herewith our check such and such for 45,64,633. Overdrawn such and such in full and final payment of our dues as per details. That's, my lord, that dues which was indicated for the month. Balance as claimed by you, 48, less payment made by us on behalf of placing indents as per instructions 75. Excess payment made by our or whatever is that 1,77,000, he gives details and he plays one. You are requested to pass necessary entries in the books and accounts and square up your accounts against the earlier outstandings. The next letter, my lord, your lordship will find another 2 or 3 letters of it. Huh? My learned indicates, my lord, the letter is dated 30th December 2004, but please to enclose here with a check for 6th of January 2005. So he's also giving me a post-dated check. This was 30th December.
Yes.
Well, let kindly come to page 47. Kindly note the date, it's 5th of January 2005. So by this time, June, July, August, September, October, November is gone. that period is lost. Now we are dealing with January, February, March. Unless, my lord, your lordship holds that no, it was one-time obligation to pay entire. At any time they can withdraw. 5th January, my lord, your lordship, my lord, notes, you are dated such and such. With reference to the above in continuation to a letter of 28 December 2004, which is wherein we enclose 3 checks of 75 with respect to supply of iron ore to our sponge iron, we further request you to, we are further pleased to enclose the following checks. These are the post-dated checks, 2 crore 25 lakhs. Kindly turn over the page. We will once again observe from the above checks that we have left the dates blank. You are requested to fill in the dates and present these checks to the bank only after the checks have been dispatched to us. That's not 100% payment, advance payment. Before presenting the checks for clearing, kindly intimate us of the same to enable to make us necessary arrangements. So, my lord, he was not in a position to make 100% payment.
Now, this is for which period?
This blood has to be for January. This doesn't indicate, because the claim proceeds on the basis that as if 7,000 into 12, 80,000 I am to supply him. It can be monthly, it can be staggered, it can be at one go, everything. And Miller, the reiteration of the process that was required is in the last paragraph. Again, you are requested to place indents for Rex 15 so and so, Miller, 15 to 85 to 18 is this arbitration, and 10 to 33 is the other one. So that we can get seniority in due course, the indents may be placed for the following destinations. So that is required. Now, so he doesn't make me 100% payment in 5th of January.
Why don't you? Why do you say no payment of?
Because, my lord, 100% payment would mean that I will receive payment and thereafter. No, you have given me an undated check with a rider that please don't present the checks because I have to arrange for funds. So money has not come into my coffer. I hold a check at this mercy to be presented.
Right.
So, my lord, my obligation under the contract does not arise as of now. Now, my lord, after 5th of January, my lord, the next letter your lordship will find at page 117.
Yes.
This is 15th of March. January things stood like that, no payment made, and this is 15 days prior to the expiry of the contract. Kindly refer to the MOU of 11th March for supply of 84,000 metric ton of sponge iron. Kindly similar, the language 7,000 per month has now been converted into 84,000 a year. From between 1st April 2004 to 31st March 2005. Then please note that MOU such and such was received on 11th. Please note that against the MOU till date we have received 11,287 of the material. As a result, which the shortfall works out to 84 minus such and such. I mean, the figures are slightly here and there, but the MOU is expiring on 31st of March 2005. And we would request you to supply the material positively within 31st March 2005. My obligation was only 7,000 per month, not the entirety of it. Please also refer to a letter dated such and such, wherein we refer to the meeting held on such and such, when we kindly assured that the iron ore would supply would be made to us as per MOU. It is important to note that till date not a single indent has been raised, such and such. Now, my lord, kindly see the date of the meeting is 23rd of December 2004. And thereafter I have said to him that make 100%. That is why this meaty as to who transpired, what transpired, doesn't have much reflection in the award at all.
Yes.
The next letter is 29th of March. It's 15th of March on the same day, which is at page 52. কারণ আমি দেখলাম তোমার একটা প্যারাগ্রাফের অ্যাওয়ার্ডে few letters which I could not find. Page 52, Millard.
Yes.
I write to him with reference to your letter of 15th March, that is at page 117. This is to inform you that as per the terms of the MOU, the material can be supplied only in case participate in the tender. You have not participated in the tender. And there is no surplus quantity available after fulfilling the committed quantity to the highest bidder. So nothing is left. Highest bidder has taken everything. It is not possible for OMDC to supply the materials at present, so and so. And the next date your lordship will find is 29th of March. This is one day. I'm sorry.
Hmm.
53 Miller. Please refer to a letter dated such and subsequent discussions had with you at our meeting on 2005. We are returning herewith the following checks for supply of the above materials. These are the post-dated checks, Miller. The first three, your lordship will find is in respect of the other arbitration, and the balance is in respect of, Miller, this. In this connection, please note that we have honored the MOU such and such for sponge grade iron and request you to participate in our forthcoming tender to enable us to supply the material as per your requirement. So, Millard, I return the checks. And the contract comes to an end a day thereafter. Thereafter, Millard, your lordship will find there are two letters. One is at 19th of April, which is at page 23.
Yes.
This is, Millard, his grievance, which he has he said, you are requested to kindly withdraw the letter and supply us the remaining quantities, but by this time the contract has come to an end. So, if the contract has come to an end, Millard, this letter written subsequent to the date of the letter, Millard, will not come within. So, but since the arbitrator has taken note of it, Millard, I am just showing it. And Millard, page, just this is the last letter. Lordship, give me a moment.
Page 54, there is another letter.
54.
You write.
Huh? This is Millard, subsequent letter to asking him to participate in
that is different.
tender. This is, Millard, all that transpired between the parties between this people.
Yes.
Now, my defense before the tribunal was that under the terms of the contract,
Yes.
there was no waiver. Defect materials, I am not going to what my defense. And I had no obligation to supply unless you give me the money.
Yes.
This was the main two defenses. And that supply was not automatic. It was not the obligation, as if the obligation starts from me that every month after the highest bidder takes, I am obliged to. Now, Millard comes straight to the award. And thereafter, Millard, I'll go to the order passed by the learned, ki judge? Parashat court.
What court?
by the Barashat court, my lord. This is 37, my lord.
Oh, right. We are taking it as a 34, in fact.
No, my lord. The reason is, my lord, if your lordship sees the 34 order, my lord, with utmost respect, my lord, I could not match the recording and the reason. But that's the reason, my lord, I showed this. Kindly come to the award statement.
You'll first show us the award, then
Yes,
the 30.
Because the tribunal, the court proceeds on the basis that the arbitrator has appreciated the facts. Correct. Millard, I just give your lordship, Millard. It will take some time, Millard. I'll place it, but I have to place it, Millard. I'll have to place it.
This is which part, Mr.
Millard, this is part 1. Award starts from page 64. It's 100 and, but I'm not going to place the entirety of
One-ta
it.
দিন এদিক থেকে নিতে পারবো না, এগুলো সাপ্লিমেন্টেড। পার্ট 1টা দেখে নিন।
কোনখান থেকে শুরু করি?
হ্যাঁ, এটা আমরা নিচ্ছি 939।
প্যারাগ্রাফ গুলো বল।
939 এর পার্ট 1। এটাই পার্ট 1। 939 এর পার্ট 1 এখানে আছে? ওটা দেখুন। এদিকে সাপ্লিমেন্ট।
না, ওটা দরকার নেই।
একটু অ্যালার্ট থাকবেন, যখন নতুন পার্টে যাবে ওরা তখন ওটা দিয়ে দিতে পারে। ঠিক আছে। Yes.
Millard, the
No.
issues.
Which page?
Millard, page, I'm sorry, page 63. 63 to 64, I'm sorry.
Good. Yes.
Paragraph 7, if your lordship comes at, I'm not troubling your lordship with the facts anymore. Page 68, paragraph 7.
Yes.
In order to adjudicate the above dispute, the following issues were settled at the 11th sitting. Was there any breach of the terms, obligations under the contract of 11 March by either of the parties? Is the claimant entitled to sums claimed under the different heads? To what relief is he entitled? So these were the 3 issues that were framed with. আমাদের একটা কাউন্টার ক্লেম ছিল তো, সেলস ট্যাক্স ডিক্লারেশন ফর্মস, সেটা লেখে নি এখানে। Millard, kindly come to কোথা থেকে বলতে? Millard, page 89, if your lordship comes.
Yes.
89. He discusses the statement of claim, the counter statement, and thereafter Millard takes up the first issue, and at page 89 we therefore reject the claim. So prior to that I am not there. Now the next claims are for such and such respectively on account of excess amounts spent by the claimant in purchasing such and such as pond iron. These 2 claims can be considered only after adjudication of the issue as to whether there was any breach of the terms and obligations under the contract, dated 11th March 2004 by either of the parties. If it is found that the breach was committed by the respondent in supplying the goods under the contract, then only the claimant may be entitled to get relief for such breach on the grounds as claimed. The contract between the parties has entered into supply of 7,000 metric ton or such and such as contained in the agreement. Then below the contract clauses are there. In the instant case, this is where Millard starts. In the instant case, admittedly, from the date of the contract up to June 2004, the respondent altogether supplied such and such of goods time to time at 1915 per metric ton. The respondent also admittedly did not supply the balance agreed goods to 7 such and such. According to the claimant, even out of the total supply made by the respondent up to June 2004, there was complaint of inferior quality of such and such of goods, for which the claimant has also made a claim in this proceeding to the extent of 27 lakhs, being claim number B at paragraph 36 of the statement of claim. We have already dealt with the claim by the claimant and we have rejected the same. The non-supply of the balance quantities of the said goods has been stated in paragraph 18 of the statement of claim. It was the claimant's case that, as per usual practice, the claimant sent undated checks towards the price of the goods with a request to the respondent to present the same after being filled up after issuance of delivery orders. That's that letter of December which they're talking about. According to the claimant, the respondent did not supply any further goods out of the total balance quantities, notwithstanding several reminders and specific promises made by and way of the respondent in the meeting held in December. This fact of reminder and the meeting has been stated by the claimant in paragraphs 20, 21, and the respondent, on the other hand, admitted supplies have been made up to June 2004 at 1915. But while dealing with paragraph 18 of the statement of claim, stated in paragraph 8 of the counter statement that after June, no request was made for effecting any supply. Sorry. Well, I am at page 92.
We're reading two together. So,
Well,
please carry on.
2 awards.
No.
Oh, the evidence.
Our own comparison. You can carry on. We are following it.
So, in paragraph 8 of the statute, no request was made for effecting any supply. There was a huge default by the claimant towards the price of goods, and accordingly, no question arose for supplying the balance goods. That was our case. The respondent also denied in paragraph 9 of the counsel having meeting with the parties with regard to supply, and then so and so. The respondent, however, in their counter statement did not dispute the usual practice of sending undated checks and the fact of sending a check of 25 lakhs to the respondent as stated by the claimant in paragraph 19.
No, but the 5th January 2005 letter says that please find enclosed. So they admittedly in that letter, they admit that they're sending the checks along with that for the first time. There is no proof that previously nothing on record.
So to cover that, he says, as I'll come.
You did not deny.
I did
Usual
not
practice.
supply. The obligation was on me to supply irrespective
Yes, that is there. Yes, and also you did not dispute the usual practice.
So,
but practice
is what is
was
admitted
implemented. That is there is a.
Then there was question of no dispute.
Yes.
It is mentioned that out of non-supply of the balance quantity of 70, the claimant had procured 47 from the market at a higher price, and that is why the claimant made the claim for the difference amount, that is agreed price and the price at which the quantities had been procured. For the rest of non-supplied goods, the claimant made a claim for damages and such and such. Therefore, this is very important. Therefore, in order to adjudicate the above claim, it is to be ascertained as to whether the respondent was in fault or committed breach in supplying the balance quantities. Apart from the grounds taken by the respondent as stated above, it is stated that no request has been made for supply of the claimant and there was default in payment of part of the prices of the goods by the claimant. According to the respondent, the clearance of such payment was made on 30th December 2004, that is below that part payment, and therefore there was no supply after June 2004. It is also the case of the respondent that the claimant did not participate in and thereby did not become the highest tenderer. Further supply, according to the respondent, was therefore dependent on the participation and tender and becomes the highest bidder.
That is probably a wrong argument on your part. I mean, that cannot be an absolute argument because there was a default clause also that even if they don't participate and become the highest bidder, they have to match, and then it will be May on your part.
Your lordship will find
May.
If your lordship applies the timelines over there,
yes,
this letter that you participate in the tender,
that is for the next tender.
Yes, when this one year period has expired, that letter is for the subsequent period when the agreement has come to an end. It is also the case of the respondent. Respondent was under no obligation to supply balance quantities. In support of respective parties with regard to the breach of terms, several documents have been disclosed which are marked as exhibits. The parties have also laid oral evidence through their such and such. The evidence respective witnesses are taken down in verbatim. The grounds according to the respondent for non-supply of balance quantities of goods by the respondent can be summarized below. There was no obligation at all to make supply in the first place. No supply was made in as much as 100% payment was not made by the claimant. No supply was made since the whole outstandings had not been cleared. No supply was made by the claimant as the claimant had failed to participate in the supply. No supply was made, there was no material. So these are the 5 defenses. Apart from the above point, it is also the contention of the respondent that the claimant had also failed and neglected to supply the sales tax declaration forms in respect of the supplies made by the respondent, and thereby the claimant had committed breach of the contract. It is submitted by the learned counsel on behalf of the respondent that since there was default in payment till December 2004, no supply was made by the respondent. Over and above the same, the supply was in any event dependent on payment of 100% advance in terms of the agreement, and in the absence of such advance payment, according to the respondent, it was not responsible to supply any further quantities to the claimant. We considered this first point as to whether 100% advance payment was really a condition precedent for supply of goods. We have to go back to the period between March when the agreement was made and the month of June when the last supply was made by the respondent. In response to the submission of the respondent about the 100% advance payment, it was contended by the learned counsel appearing on behalf of the claimant that as a matter of fact, the respondent had never given any importance to this particular term of the contract and had relaxed the same by supplying the materials up to the month of June without 100% advance being demanded of or made by the claimant. According to the claimant, the clause of 100% advance payment as contained in the agreement in question had been waived by the respondent, and accordingly the respondent cannot take shelter of 100% advance payment clause to get rid of the commitment obligation to supply the contracted quantities of goods. If we now assess the factual position during the period between the date of the agreement up to June 2004, this is the period which he is examining continuously. We find that the respondent had supplied the goods in April, May and June 2004 of different quantities at an agreed rate of 1915 per metric ton, which was lifted by the claimant. It further appears that neither the claimant had made 100% advance towards the price of the goods to the respondent, nor the respondent had insisted on payment of the same prior to actual delivery. It is also a matter of record that towards the price of goods supplied by the respondent during the period April to June, the claimant had made part and or ad hoc payment by checks, which was received and or encashed by the respondent without raising any objection. From the aforesaid, it can be inferred that the respondent was in fact not serious about insisting on 100% advance payment clause as contained in the agreement as a condition precedent for supply of the said goods. Had it been so, the respondent would not have supplied the goods without receiving advance payment for the same. Pausing here for a moment, my lord, this probably, my lord, would be nullified by the subsequent correspondence and conduct of the parties. There cannot be waiver when I have said that you make 100%. There cannot be waiver. In support of the contention of the claimant to the effect that 100% advance as contained in the contract was waived and or insisted upon by the respondent, in course of execution the claimant's witness Arup Agarwal, Ajay Tatia had given evidence by of affidavits. 2 witnesses were cross-examined in this such and such. Obviously, they mentioned that 100% advance payment clause was mutually waived and the supplies were made under the normal terms. This is oral evidence vis-a-vis the conduct and evidence in writing. Be that as it may, this is the evidence that the claimant had led from the course of conduct. Then, the respondent's oral evidence was taken. Now, kindly see, the respondent had laid oral evidence through Tapan Ghosh, who in his answer to question 15 to 21 in cross-examination stated that the goods were supplied during April to June by 8 rigs. Very good. Exhibit H is a document which speaks on support of the statement of the witness, correct? In question 22, the Tapan Kumar Ghosh has also confirmed that the bills were raised on each such rigs. This is in respect of that supply. Further, in answer to 20, the said witness of the respondent stated that instead of 100%, the ad hoc payment was made by the claimant and received by the respondent, and subsequently the entire dues were cleared. The said witness of the respondent in question 29 in cross-examination confirmed that the supplies which were made between April to June, no demand was made with regard to 100% payment. And first of such letter was written only on 24th December, that is Exhibit 12. So he takes note of that letter, my lord, where? My lord, your lordship can now come to paragraph 61. I don't think, my lord, this would be relevant, but Mr. Shah will assist if he finds anything there. Paragraph 61. Therefore, from the evidence available in record and from the oral evidence of the witness of the respective parties, it is apparent that although a clause for 100% payment, advance payment was incorporated in the agreement as a matter of fact, the parties had not followed the said terms and rather waived the same by not specifically enforcing such 100% advance against the clause. If the clause being 100% advance was a condition precedent, respondent could not and ought not to have supplied 8 rakes of goods in the span of 3 months from the April to June 2004 without 100% advance for the same. Rather, the respondent had not only allowed the claimant to take delivery of the goods without payment of 100% advance, but also unconditionally accepted part payment and or ad hoc payment towards the price of the goods. Then, it is also significant to note that until 24th December 2004, there was no whisper, sorry, my lord, there was no whisper on the part of the respondent with regard to 100% advance for future supply. There was no demand.
Next line is otherwise.
Yes.
All the records show that the claimant continuously made demand.
And supply of goods. We shall refer to these demand letters at a subsequent stage. My lord, pausing here for a moment. Kindly, my lord, come to.
There were demand letters in the interregnum.
My lord, the letters which I had shown, my lord, are the 2 letters. And my lord, I had told Mr. Shah, I could not find these 2 letters on record, which is at page 84. Paragraph 84. Which he says subsequently, these 2 letters which say, my lord, my learned friend will assist me if I am wrong. I have checked up with my junior. These 2 letters are not on record, but these 2 letters are of November and December.
Those are referred to in paragraph 84.
84. In respect, in context of another issue, but I believe, my lord, this is where he is referring to. Because apart from this, there is no reference to any other letter.
Are there any 2 letters in the other matter?
Other matter, yes? No.
All right.
Because since he has said somewhere, I could only find this paragraph, and my learned friend will correct me. There is no other paragraph where he refers to any such demand.
Para 84 says that
yes,
demands were
that's
consistent.
That's the reason why I brought it to your lordship's notice.
But even if demands were made, Mr. Dattu, your argument would probably be no advance 100%.
No.
So entire case is dependent on the waiver issue.
My lord,
in a sense.
If the waiver issue goes, my lord, then there is no breach on my part. If there is no breach on my part, my lord,
yes,
loss, damage, everything goes. My lord, may I?
Because this is damages in for breach.
For breach.
Not in lieu of.
2. One is he is procured because he says between June to November I have procured from outside.
Right.
But there is no evidence to show that since I have failed to supply, he has.
There is no breach they obtained from elsewhere or not, that becomes
no difference to. Waiver of 100% advance payment also appears from the conduct of the respondent, inasmuch as the respondent allowed the claimant to take 8 rakes without any demand, but he is only constantly harping on that 3 months. Had it been only one supply through 1 rake without 100% advance payment, then it could have been presumed or considered that the respondent had allowed such solitary supply as a special condition. But it was continual supply without 100% advance, and therefore it can be construed that the respondent was not serious in enforcing its rights under the agreement. The respondent uncomplainingly continued with such supply against ad hoc payment but not the 100% advance. Therefore, the contention of the claimant can be accepted without any hesitation that the parties did not agree to enforce the 100% advance payment as against this agreement. In this connection, another point is also significant. The respondent had raised 8 several bills against 8 several supplies. This itself shows that the sale of goods under the normal terms of supplies bills would be raised and payment to be made in accordance with the bills.
What about these 8 supplies?
Well,
Because 3 months only.
3 months supply was made by 8 rakes.
So these eight bills are restricted to those 3 months.
Yes, yes. There is, I don't see there is any supply thereafter, because the basis of their claim is that 7,000 into 12 minus
Yes,
what?
yes.
Yes, that's the
They
basis of their
calculated.
claim. Therefore, it cannot be accepted that no supply was made as 100% advance, but was not paid by the claimant. We therefore do not accept the contention of the respondent the claimant had committed in breach of 5C of the said agreement by not paying 100% advance, and accordingly such plea is rejected. From the above discussion, it also appears that this is another. From the above discussion, it also appears from the conduct of the parties and by necessary implication thereof that 100% advance payment clause contained in the agreement has been given a go-by and or waived by the parties. In fact, the respondent decided not to take 100% advance against the supplies, which would also be evident from the respondent's letter of 15th March 2005 at page 90 of the brief of documents at page 18. That's the letter which I showed to you. Does it, my lord, in any simple way reading, show that I have accepted that payment as a part payment for supply, my lord? Because this entire payment issue was engineered by my first letter of December that first pay your old dues and pay me 100%. Therein, respondent intimate that since the claimant inter alia did not participate and it was not possible for the respondent to supply them it. Therefore, the plea of non-supply of goods without 100% advance is not tenable.
70% of the award is dedicated to 100%. Yes.
We shall consider the remaining reasons for non-supply of goods at a later stage, but in the present context, it can be said that in view of the discussions, that non-supply of goods by the respondent on the plea of such and such advance is not acceptable, and therefore, by making no further supply goods, the respondent has committed a breach. Now, my lord,
we are minded to set aside the award once again the term 100% is used.
Another significant point with regard to the alleged non-payment of 100% is in spite of the payment, kindly see, my lord, in spite of the payment of the total sum of 3 crores by the claimant on 28 December 2004 and 5th January, this is the post-dated checks which, my lord, complete misconstruing, my lord. The respondent did not supply the goods covered under the said total sum of rupees 3 crores. In this connection, the tribunal and learned judges have clarified with regard to the contents of the letter of 29th March 2005 and non-delivery of the goods against check. Mr. Sen, in his argument recorded in the fairly considered that that page 91 of the brief of document does not refer about 100% payment as the ground for non-supply. This is the letter where we are refunding the checks just one day before the contract is expiring. Now, my lord, this is all that has to say regarding 100% payment, the first agreement. Now, my lord, kindly note the very important letter which he has taken note of is the letter of 28th of March where I say pay 100%. And that evidence has neither been, it has been taken note of, but not dealt with anywhere. Because that would be the answer to the waiver.
Your letter of 24th December.
Yes.
Page 45.
Yes. Where I say that clear the old dues and pay 100%. Otherwise, no supply. So, my lord, this is so far as waiver is concerned, according to him. Then, on this basis, my lord, at paragraph 66, Therefore, even if we assume that 100% advance payment was a condition precedent for supply, nevertheless, it appears that the respondent, even after receiving advance payment of 3 crores, did not supply the goods. There was no advance payment at all. Therefore, undoubtedly, a breach was committed by the respondent towards the claimant by not supplying the said goods, although the check was returned on 29 March 2005, 2 days before the expiry of the contract. No explanation has been given by the respondent as to why supply was not made against the amount already paid in advance to the claimant. There was no payment, as I have said so in so many words. So this is Millard where he holds that so far as the third quarter is concerned, even if I had given you post-dated checks with an instruction, so that he takes to be as 100% payment in advance, and he says you are compliant. So this
That's not an advance, first of all.
A.
It's not a payment also.
Yes. So Millard, except for these 3 months, there is nothing on record.
The entire premise is waiver, basically.
Now, Millard, the other points which Millard, Lordship, it will come back to your Lordship, he had noted down the 5 defenses that I had taken. Now, Millard, so far as your Lordship can make a note, in subject to availability is the next ground. Non-participation in tender is paragraph 67 onwards. The finding Lordship gives me a moment. I have made so much of note, I am getting confused. Huh? No. Millard, now I'm sorry.
So just so up to now this was waiver.
Waiver. The next grounds I'll come. My lord, I was at page 106, paragraph 67.
Right.
On account of, this is, my lord, where he starts dealing with the second defense, non-participation in tender.
Yes.
The next ground for supply of goods by the respondent to the claimant is that the claimant had not participated in the tender and supply was subject to availability of the same. In this connection, the relevant clause in the such and such is quoted below. Now, my lord, kindly, my lord, reflect back to the letter where I asked him to ask for participation in the tender.
Mr. Datta, there appears to be a confusion between a defense on the basis of the next tender and that clause in your contract with them, MOU, regarding if they don't become the highest bidder, participate and become the highest bidder, then you may supply. Probably there's some confusion between the two.
What has happened is this, my lord.
The confusion was due to your stand because you
because
you
I
had
should
taken a
have,
stand.
I should have said that
Simplicity.
after expiry of the contract,
Right.
there was no question of supply unless.
Once you cite that ground, you may relate back to that clause also.
But my lord, if you, that's the reason why I was saying this, my lord. That is what, that kindly visualize that portion
Later.
is post April. But my lord, he holds, my lord,
But they had asked for supply during the subsistence of the earlier contract within that 1 year. In reply to that, you had probably stated that one of the grounds you cited was that you did not.
my lord, the last phase, January to March, when they say that I have given you 3 crores of rupees, in reply to that, I said there is non-availability of.
You also probably cited non. Please let us come back to that later. We'll just
yes.
have a relook and then continue with
my
your letter. Page 52 probably.
52, my lord.
52, yes.
52.
See both grounds. As you have not participated in the tender, and that's in reply to their claim on the basis of the
3 crores, 3
yes,
crores of rupees.
yes.
And there is no surplus quantity.
Surplus quantity is also there.
No, because he is also held that this is also a bad defense.
That is a better ground for you. But regarding this non-participation of the tender,
It should have been for the post.
Yes. But even if we, I mean,
the bottom line is payment.
Yes, we negate this ground of yours. This
bottom line is there.
Anyway, let us carry on with the.
Yes, because I'll have to take your lordship to the other judgment also. My lord, he negates this clause. My lord, kindly come to 72, paragraph 72.
Yes.
But I'm skipping the arguments and thereafter the finding.
Absolutely.
The respondent's contention accordingly does not get support from the contract itself. If it was the intention of the parties that supply would be made only on participation or tender and becoming the highest bidder, in that event there was no necessity for the claimant to enter into a separate and independent contract of the respondent for purchasing the goods for 1 year. This defense would have been good post April. If we specifically analyze clause 5C of the contract, it would appear that supply of 7,000 metric ton goods in the month under the contract was in any event guaranteed.
Guaranteed is wrong.
But only the price of the goods has to be paid to the claimant at the price and other terms and conditions accepted by the highest bidder.
But the conclusion we rather agree with that.
Therefore, this clause
cannot be construed as a condition that supply would be made, not be made unless they participate in the tender. Guaranteed party, yes, you are right.
Now, thereafter, my lord, subject to availability is paragraph 74 onwards. The respondent has also contended that the supply of the goods under the contract was also dependent on the availability of the same with the respondent. The obligation of the parties against each other under the contract intended to be gathered from the 4 corners of the agreement and not otherwise. Respondent having entered in the contract is obliged to perform his obligation by supplying the materials agreed therein. In clause 4 of the contract, the respondent has agreed to provide 7,000 metric ton per month to the claimant under the terms contained therein, subject to availability of the same. Therefore, we have to ascertain from the facts, pleadings, documents, evidence as to whether respondent could not supply the goods because unable to say. In para 9 of the counter statement of the claim, the respondent has only stated that the said clause of the agreement was supply subject to availability. There is no whisper in anywhere in the counter statement of the claim that the respondent could not supply the balance goods under the contract as the same were not available. On the contrary, the respondent has sought, although stated in the counter statement, the supply was not made as the claimant did not participate in the tender and has not paid 100%. He is taking the first half, he is ignoring the second half of that letter, which you lordship. We do not find any document disclosed by the parties in the present proceedings that the respondent intimated the claimant that no goods are available with them to supply to the claimant. This is directly contrary to the letter which at page 52. The respondent has not disclosed any contemporaneous document to establish that no goods were made available at the relevant point of time for which they could not make supply.
So courts,
He holds this
contemporaneous. Yes. He says no. Subsequently, you stated.
No, it can't be, because that is that series. If your lordship sees those series of letters, my lord, how more contemporaneous would it be? And my lord, he holds this also for the period during which there was no from June to November. He holds this good for this entire period. He doesn't.
He means that by contemporaneous, perhaps. That for that period you have not
So
shown
therefore,
anything.
my lord, it will come back to that question.
But they did not make any. They have
no payment. Number one.
Also, no letter is there from their part during that.
Yes.
We'll check that. Yes.
It is significant that while the claimant made several, this is where, my lord, he is again coming. It is significant that while the claimant made several demands in writing from time to time for supply, the respondent neither replied to the same nor had otherwise intimated that they do not have any material with them to supply. Further, the respondent by the letters, kindly, my lord, when it comes to records, he goes back within that period from December to March. From the records of 15th March, 29th March, stated the reasons for non-supply, which, my lord, I need not repeat myself, does not say what the arbitrator is coming to. Then, my lord, so this, therefore, my lord, he says that this is no ground. We do not accept this plea and is rejected. It starts at page 117 top. Now comes, my lord, no demand for goods. Another plea that was taken by the respondent as a ground for non-delivery of goods, that no demand was made by the claimant for supply of the same. This was in the written statement. We take this point. The respondent's witness so-and-so, although had said nothing in his affidavit evidence to that effect, but in answer to cross-examination, he stated so. In this connection, 31 to 36 of Tapan Ghosh's examination has been set out. Whether the contract, this is where he frames the issue, whether the contract contains any provisions for advance demand for supply. The contract admittedly does not contain, paragraph 83, Miller. The contract does not contain any provision with regard to making prior demand for supply of goods. But the evidence from June and October, those two letters will show that there was a necessity and that the parties had followed that. It is significant to note that supply admittedly made by the respondent between April to June were without any written demand made by the claimant. Had there been such provision or arrangement between the parties, the respondent could not have supplied those goods during the span of 3 months of time without being in. Secondly, this is the paragraph, my lord, where he refers to, in any event, demands were consistently made by the claimant for supply goods from June 2004. This letter I had shown to your lordship, my lord. It has to do with the defective inferior goods. and would also appear from the claimant's letter of 14th October 2004. This letter I have also shown to your lordship, which says that I am ready to match the price which is now prevailing. Kindly place the indents, but no payment. These are the only two letters. Letter dated 19th November at page 79 and 14th December. Milord, 14th December is there, but the 19th November letter I could not find it anywhere.
What is this brief of document? These were the records of the arbitral tribunal.
Miller, obviously, this would be, but it's not there. Irrespective of the above position, he doesn't go on this. Irrespective of the, again, it is the contractual obligation of the seller, being the respondent herein, to supply the goods under the contract, irrespective of any demand made by the purchaser, being the claimant. The supply of the respondent in any event does not and cannot depend on any specific demand made or not made by the purchaser, being the claimant. The respondent is bound to fulfill its contractual obligation in the contract by supplying the goods to the claimant, subject to fulfillment of reciprocal obligation by the claimant. Well, he admits that there is a reciprocal obligation to pay. The obligation for supply of the goods under the contract cannot be diluted and not denied by mere taking the plea that no demand was made by claimant for such plea in submission is absurd under the provisions of the Contract Act and the seller. Then, Millard, he goes on to hold that these 3 crores of rupees in any event, Millard, at paragraph 87, Millard, let me place it, Millard. It appears from the pleadings and evidence of the respondent that the respondent, in fact, at different places have taken different plea for non-supply of goods. In some places, it is stated that the supply was affected because of non-payment of advance, where in some places taken the point that the claimant did not participate in it. Again, in another place, it has taken the point of non-availability of goods with the respondent, and finally, it is stated that no demand was made by the claimant to supply. All these defenses fit into different stages of the contract. The letters, the evidence. But he's taken all in one basket. In answer to question 30, respondent cross, however, stated that the competent authority had taken decision to stop supply because of outstanding dues. The witness does not refer to any other ground. Even if we take this answer of the respondent as correct, it is not so factually, because the claimant had made full payment for the supplies which were made up to June 2004. Which may be delayed, and had also tendered payment towards supply to the extent of rupees 3 crores, which is those checks.
Yes.
Which are ultimately returned by the respondent on the ground of non-participation in tender. So therefore, even the final stand which has been taken by the respondent witness is contrary to record. Then, my lord, your lordship will he speaks of, my lord, some oral contract.
But one thing is there, Mr. Datta, you, from April to June, you accepted part payments.
Yes, I did. I did.
Yes.
I did.
So Mr. Shah must be arguing that would be a waiver. I mean, if you accepted nothing.
No, my lord, what I am saying is this.
If you accept part payment, aren't you waiving that 100%?
No, my
For
lord,
3
that
months
is
you
where
do
I
that.
come in, my lord, is that let's proceed on the basis that April to June I had waived.
You say that cannot extend to the entire period.
That cannot extend to the entire period, A. And B is, I have put him on notice that there is no waiver. Even if your lordship takes it to be on waiver, I have put him on notice that there is no waiver.
But that putting him on notice was not contemporaneous, subsequent.
Because
When
from June to December, your lordship will
there was
find
no claim.
there is no claim. So the moment he asks, I say pay.
All right. Very.
Now, my lord, the damages has been discussed from paragraph 90 onwards. That he had to procure goods, and kindly, my lord, come to 101. 101. 101. My lord, he has discussed the claim for damages.
Paragraph.
But 101 is his finding.
Right.
If your lordship wants, I can place this, my lord.
No. 101 you want to place.
101 is the finding. So let's go by the
Yes,
finding.
yes.
While dealing with the first claim on account of difference of price of goods, we can say that the claimant was entitled to claim such difference of price from the respondent. As a matter of fact, the claimant, by procuring parts of goods from the market, has in fact mitigated the damage which could have been the liability of the respondent. The respondent cannot avoid the liability towards the claim on account of such difference of price for which the claimant had made a claim in the proceedings. We have considered the claim of the claimant and we are satisfied that the claimant is entitled to get an award for a sum of 13 such and such 0.12 paisa on account of damage, and we accordingly pass an award for such sum in favor of the claimant. Now, my lord, this entire finding has two aspects to it. One is it is entirely dependent on the finding of breach.
We were thinking about in the lines of section 72 and 73 of the Contract Act also.
Yes, I am also there.
Because he had to show that he could not have mitigated damage. I mean, if there is any damage at all. For that, he probably had to prove that the price matching that aspect of the matter.
That aspect
That
of
he
the
had to
matter,
pay more than that.
yes, that it has to be put at a higher level because
Higher
it
level.
is not a profit-making clause.
Right. And the balance would have to be the damage. Because suppose the price which he had to match was rupees 10 lakhs, say, and if he had to pay 12 lakh, then that 2 lakh would be probably
Yes,
the excess amount
yes,
that would be the
yes.
damage.
But here, my lord, there is another aspect to it. If my learned friend was conscious of the fact that he was mitigating his losses, then there could not be any question of loss of profit. Because if I have in a position to procure, because the loss of profit is not dependent on this ground. The loss of profit is on the ground that I had standing orders, which I could not supply because you did not supply. Now, if you are procuring it from the market, then why did you allow the you to suffer a loss?
And the award says that he mitigated the damage.
And the statement of claim also proceeds that I purchased this amount of material and thereafter I did not. So a litigant conscious of the fact that he is, suppose he's a businessman, Miller, he will not be putting his entire stake on what would be the outcome of the arbitration award. He may be having his rights, but he will obviously try to mitigate, and he mitigates it only to a portion of it, and thereafter he says, I did not. When Millard, of course, Millard, at the cost of reputation, he was in breach according to me in performance. So, Millard, this is all. Lordship, give me one moment. Hey. Purchase order 2. Millard 10T2 is Millard on account of loss of profit.
Yes.
Millard, kindly make a note. Kindly, Millard, come back to the statement of claim once. What is the basis of his claim? Paragraph. $35. Millard, kindly come to Millard page 10, paragraph 35. I'm sorry, page 11, paragraph 35.
Yes.
For manufacturing 1 metric ton of sponge iron or pig iron 1.60 metric ton of sponge grade calibrated iron of 65 Fe is needed at the plant of the claimant. For not being able to procure this 23009 metric ton of sponge grade calibrated at 65, the claimant failed to manufacture 14380 of sponge iron or pig iron, for which the claimant suffered loss and damage aggregating to 1,43,86,87.50 paisa. So the basis of his claim is his cost plus what he could have marketed. The claimant is entitled to and claims damages which arose of failure on the part of the respondent in not fulfilling his obligations, and he has come to this amount of 143,86,50. Now, my lord, kindly, my lord, vis-a-vis take page 102 onwards. Page paragraph 114.
Yes.
Evidence नहीं है। Well, lordship, supplementary paper book type of it. It is part of evidence, तो क्या तो 1000 पढ़ले की दाঁড়াবে?
Yes. Supplementary paper.
Well, supplementary paper book, my lord, your lordship will come to page 20 straight away. My lord, paragraph 42 starts from page 19 and the basis of it is given in his evidence. Page 19 and 20, paragraph 42 of the evidence of the claimant. In view of the contract entered into by the respondent for purchase of 7,000 metric ton of such and such per month, during the period thereof, the claimant had undertaken specific supply obligations based on the supply commitments of the respondent. In view of the failure on the part of the respondent to supply any goods to the claimant after June, and in further view of the claimant's inability to procure 70 so and so of metric ton even from the market to meet its supply obligations, the claimant was unable to supply ATO 14380.86 metric ton 6 sponge iron against supply. Consequently, the claimant lost profit of 1,43,80 on 143 so and so quantity of sponge iron, which could have earned by supplying the same. Accordingly, the claimant suffered loss of profit to the extent of such and such. In this context, it is relevant to state that the claimant operates on a minimum profit margin of 1,000 per metric ton of sponge iron. Now, kindly, my lord, come to the second witness at page 29. Claimant's witness, page 29. 20%. Then, sorry, my lord.
Page 29.
Page 29 is the evidence of the second witness.
Yes.
My lord, he has a different version to say. Page paragraph 8.
Yes.
My lord, middle of that paragraph, I have ascertained, has my lord got it? I have ascertained that Sri Ram Balaji so did not enter into any agreement, transaction, which did not provide for profit at all, at least profit of at all, at least 20% or rupees 1,000 per metric ton. So now it's coming down to 20%. Now this is the basis of the evidence that is available before the arbitrator. Two statements. Now, what does the arbitrator do? Kindly come to page 114. I'm sorry, paragraph 114.
Yes.
99 to 100. Paragraph? Okay. But my junior wants me to place from paragraph 113.
Absolutely.
In the instant case, we have unambiguously held that the respondent has committed breach of the contract. So, he proceeds on the basis of breach. And therefore, it is liable to pay damage to the claimant. The damage which has been claimed in the instant case is not remote. The non-supply of balanced quantities of contractual goods obviously prevented the claimant to use the same for his manufacturing process, and sufferance of damage is a natural consequence which cannot be disputed. The claimant, according to its own calculation, has quantified the damage, and while quantifying such damage, in the state, it has stated that through the witness that the relevant point of time 20% profit margin was always there. The damage which has been claimed in the instant case by the claimant is not by way of penalty. In commercial transaction of like nature, according to us, profit margin may vary between 15 to 20%. According to us.
Yes.
In the light of the ratio of the judgment in Gambhirlal's case, it is, however, difficult to estimate damage which certainly or precision. Since it is difficult to estimate such damage with certainty or precision, the loss of profit as claimed by the claimant can be estimated on the percentage basis. Considering the facts and circumstances of the case, and upon considering the documentary and oral evidence of the respective witnesses and the submission made in this behalf, we hold 15% profit margin would be reasonable and appropriate for the claimant in respect of the balanced quantities of the goods which were not supplied by the respondent. The basis of the calculation of damage on the account of loss of profit has been mentioned in paragraph 35 of the statement of claim, which I just read. We accept such basis and hold that the respondent is liable to pay damage to the plaintiff on the account of loss of profit calculated at the rate of 15% profit, since the claimant had failed to manufacture 1438068, that is out of 23009 metric ton of such and such. In order to calculate the damage, the average cost of 1 metric ton of goods has to be ascertained. This is, something which is coming out, from the arbitrator. This is not coming out from anywhere in the evidence. But let's take it, he is applying his mind to come to. Let's proceed on that basis. For the purpose of such
arbitrators were commercial people. I mean, who are they? Just
the lawyers.
Lawyers.
For the purpose of such assessment, we should take into consideration the purchase orders placed by different customers on the claimant at the relevant point of time. Pausing here for a moment, Milord, not one of them had come forward to produce or prove these documents. Such purchase orders have been disclosed and exhibited in the present proceedings, which are 99 to 104 of the
What was the mode of marking exhibits adopted? Witnesses had to come.
The witnesses did come. It has been recorded. Witnesses.
So PW1 is there. Yes. Right. PW1 2 is there.
Yes.
Right.
So I believe, Milord, evidence was given by way of affidavit and cross-examination was held. And that is probably. But Milord, even if it is exhibited, the contents are not proved. So, Milord,
formal marking as exhibit was dispensed with. Then
that probably
you
don't find anywhere in the anywhere else.
Section 19 of the Arbitration Act in any case, Milord, comes into play. The general principles are applicable, but when the Evidence Act does
not applicable. Exactly. That is why we are asking that, because those are not applicable per se.
That's it.
Evidence Act and CPC are not applicable. That's why you are asking that whether the mode can be decided by the parties or by the arbitrator, if you don't agree. So whether there was any such.
But if it is a claim for damage,
because you are taking a specific point, Mr. Datta, that they did not come and prove those.
Yes.
So it was not correctly, properly marked as exhibits.
No, what I'm trying to say is that
pure civil concept.
I know that. What I'm on is that, Milord, it is a basic principle of law that if I am basing my claim for damages on a particular purchase order or challan,
unless you agreed to a mode of proof,
I didn't find it anywhere recorded in the award that parties had agreed to these documents being marked as exhibit without formal proof.
All right.
The average price of 1 metric ton manufactured goods out of the ordered quantities as mentioned in the purchase order is
We don't have a copy of this brief of documents. The tribunal is regularly referring to brief of documents. Now, those must have been a part of the records, should have been a part of the paper, because this brief of documents is the entire genesis of this entire the issue.
Yes, but
My recollection is that the brief of documents was there.
But it was not brief.
In fact, Justice Shoman Sen was opposing me in that matter, before the tribunal. But so far as the brief of documents is concerned, now after the passage of so many years, I don't know where the main arbitral records are.
Those never came to this court.
It went to the Barashat court first. And where it went from there is anyone's guess.
But
Anyway,
we have to proceed on what is there in
we'll
the
take your
arbitration.
point, but that these were not proved.
এইগুলো হচ্ছে যে মাসে সাপ্লাই করার কথা ছিল তো জুন টু জুন জুলাই অগাস্ট সেপ্টেম্বর অক্টোবর নভেম্বর ডিসেম্বর তাই হওয়া উচিত কিছু বলা নেই Now, my lord, kindly see average price of 1 metric ton goods manufactured out of the quantities mentioned in the purchase orders is calculated below. He takes a quantity which I presume, my lord, which I presume would be the quantity which
Reflected in the purchase order must be.
no, my lord, this quantity should come from me. That I don't know where is he getting these figures of 9,000, 13,000.
No, those purchase orders, the order was for 9,000 and
Yes, purchase orders.
purchase orders.
The rate is given and this is given. Therefore, if we divide the total price of such and such, this total purchase order, by the total quantity of goods, that is such and such, then cost of 1 metric ton comes to such and such. Now, if we calculate 15% profit out of such and such, then it comes to 988 as profit margin as against 1 metric ton. Therefore, in order to assess the damage at 15% in respect of 14,380.68 metric ton manufactured goods out of the balance undelivered quantities, the margin comes to this into 988 এটা কোত্থেকে পাচ্ছে ও per metric ton, and thereafter he awards this amount of 1,42,00,000. 5% reduction he made. He said 20%. He said no, 15%. The original claim was 1,43,80,000, 687.50. He has given 1,42,19,616. Whereas Miller, on calculation, it appears the difference of 5% would be to the extent of coming to difference of 1.5 lakhs. What? Just give me a moment.
If you adopt a different mode, deduction of 5%, that would create different results.
No,
As you know from our experience in mathematics.
It's coming to a different figure altogether. The 5%.
So we have to go by 15% of this amount.
So very good.
Otherwise, it will be, the answer will be 1.5 men,
Very good.
as it usually was in my
Very good.
papers. Yes.
So therefore, he has come to some basis. My first point.
Some basis is there. Yes,
Yes.
definitely.
My first point is this entire basis of loss of profit is dependent on breach. That is his first line.
Yes, that is obviously there.
That is there.
That's the underlying.
Secondly,
yes.
this, Millard, the two evidence that has come along with the documents, Millard, they are not substantiating the other factors which need to be taken into consideration for the purpose of coming to a calculation that there has been. It is not a profit-making clause. I keep on repeating myself because I have a fixed production. I may not have that order. I may not have that capacity that I was ready and willing. My factory was in a position to manufacture. There was no breakdown. All these things can be factored in. So Millard, therefore, he has followed Millard ad hoc of 15.
So two things are not taken care of. One is that the highest rates you are getting from the bidders, which could have been the standard of calculating the price. One. Second, your availability of the supply.
Yes.
Because that it would be, I mean, circumscribed by your availability at the relevant point of time if your argument. Also. Because that 7,000 was the ceiling. not the compulsion and
Right.
not a mandatory compulsion.
And there was no obligation, my lord. That is where, my lord, one of the major points. There was no obligation on me to supply 70,000 at one go. It was 7,000 maximum per month.
Yes.
And that is how the contract also proceeds, the
Yes,
statement
yes.
of claim also proceeds.
Yes.
Had he, my lord, performed, then, my lord, these questions would have, whether there was availability, what was the rate. He didn't perform that portion. So, my lord, the entire basis, my lord, thereafter, my lord, he holds. So, my lord, as I say, my lord, uh, with respect, my lord, probably the evidence was utterly misread. And the findings, my lord, do not go by the evidence that is on record or the contract between the parties. The arbitrator has gone on to change the contract, which does not, my lord, appear from the conduct of the parties. Now, my lord, the impugned order is at page 160. Oh, sorry. Sorry, my lord. Yes, my lord, on the interest portion.
Yes.
Page 1, paragraph 126. 26.
Interest is the least interesting portion actually.
The claimant would also be entitled to simple interest on the aforesaid sum of 1 crore 37. Such interest is to be calculated from 1st January 2005. Inasmuch as the claimant had procured materials of 47413 of goods from 28th May to 31st December as shown in Annexure E.
We don't get this point. The logic.
What the learned arbitrator is saying,
Yes.
if subject to correction, is that you from June, he is proceeding on the basis that from June till December, he had procured the goods
From somebody. Therefore,
somebody.
no interest is.
That entirely falsifies the first book.
Right.
So, we, however, grant such interest from 1st January 2005. Which is next date of last procurement of the goods by the claimant. The claimant would be entitled to get such simple interest at the rate of 6% from 1st January till the date of entering into the reference, that is 1st September. The claim also entitled to claim interim interest at 6%. The awarded amount. The claimant is also entitled to simple interest on the awarded sum of rupees such and such on account of loss of profit at the rate of 10% per annum from the date of award till realization. And thereafter, my lord. So, my lord, the basis of the interest militates with his finding.
Yes, rather the basis of the interest negates the previous claims.
Now, my lord, the impugned order, if your lordship comes to page 160,
At least on the count of damages and loss of profit.
yes, at least on the count of that.
Very well.
My lord, 29th February 2012, my lord,
Yes.
page 160. কি সেন্সার গেছিল আর্গুই করতে? My lord, judicial decisions, my lord, your lordship will skip.
Yes.
My lord, kindly start from page 176. Prior to that, he is examined the award and said, this is done, this is done, this is done.
Thank you.
So the parties to the instant application, Miller, second
Yes,
last
yes, yes, yes.
paragraph. So the parties to the instant application have nothing to say in respect of the two rejected claims.
They did not challenge.
The main thrust argument of both the first ground for challenge of the impugned award is decided that the petitioner waived the right. The petitioner contended that there would be waiver of statutory right at 54. Section 54 provides for this contract. Section provides that a contract consists of receivers as such one of them cannot be performed. He sets out section 54. But it is also mentioned there that clause 5C of the agreement, the respondent under obligation to make 100% payment, or so the right to get 100% payment is a contractual right of the petitioner. The learned tribunal decided the clause 100% as a condition precedent ought not to have supplied 8 days in the span. The OMDC has only allowed claim to take delivery of goods without payment, but unconditionally
So
accept.
it's almost a repetition of the tribunal's logic, waiver.
Yes, and therefore he says,
Judgments are, one judgment is considered very relevant.
yes. And thereafter he says that it is not a single supplier. He just repeats it. I am of the opinion, the last line is his reason.
Yes.
The final should not be interfered with. He repeats the award and he doesn't give his own reasons for it. Or very well, Millard, if he accepts it, then also that can be treated as a reason.
Yes, cites the judgments also.
Yes. Then Millard, the next is second ground is that I had not framed any issue regarding waiver. This is the point which I am also taking. Waiver is guilty of misconduct beyond jurisdiction, no leg to stand on, because the discussion regarding waiver had arisen. This is Millard important. Sorry.
Yes.
Millard. Learned arbiter is guilty of misconduct and acted beyond and has no leg to stand because discussion regarding waiver had arisen as OMDC took the defense of non-payment of 100% before the learned arbitral tribunal. This is incorrect. I had taken the defense, but prior to that, there is also evidence on record. It is clear that the factum was very much within the knowledge of OMDC and they could meet up the same before the learned tribunal diligently. Then he refers to some English reports and the Honorable Supreme Court. A reasonable view has to be taken, but as such, non-framing of issue by the arbitrator cannot be treated as a misconduct of himself. It was open to pray before the tribunal during the proceedings to frame an issue.
So both of you addressed the issue. Both of you were aware of what you were arguing on.
No, what I'm on is, Willard,
non-framing of issues is not fatal.
No, not at all. Because parties have consciously laid evidence on it, and their judgments galore to that.
Galore, yes.
What I'm on is, Millard, the statement of claim does not contain a pleading of waiver.
All right.
It is not that my learned friend did not know the reason why I did not supply. He knew it, so therefore he had to make out a case that the ground taken in that letter of 28 of refusing cannot and should not be a good ground because that is deemed to be waived. Waiver, Millard, can come by way of argument also if I take it in the written statement. But here is a case where he himself relies on those letters. So he was in know of this fact, but he did not come out with the even statement that there is a single line of waiver in this entire statement of claim. That is where I join issue. Then Millard, he comes on waiver. The third ground did not participate in the tender. He observes in his entirety as to what the tribunal has held. The third ground, which starts from page 180.
180.
And finding is at page 181. Millard, 4-5 lines from the bottom of first paragraph. I am in agreement with the observation made by the learned tribunal that it was the intention of the parties that supply would be made only on participation in the
That
tender.
we also agree, but subject to the other riders that you may, and the other things, 5BC, those clauses.
Yes. The fourth ground of challenge, the respondent had relied on a purported alleged to have been in the month of December 2004 for supply of such and such calibrated. কোথায় যাচ্ছ? এই, চুপ করে বসো। So, Millard, fourth ground of challenge is that the respondent had relied on purported agreement such and such. Millard, that he says that the learned tribunal has not allowed any claim in respect of any agreement of December 2004, and such plea on the present is not tenable. Very well. Fifth ground, that the impugned agreement of the petitioner has agreed to 7,000 per month and not supply the same, and the learned tribunal wrongly interpreted the supply. Then he goes on to concise Oxford Dictionary to say what is the difference between provide and make available for use. Thus, provide means supply also. As such, the contention argument for the petitioner cannot be entertained in this regard. This was nowhere, Millard, an evidence or an argument before the tribunal, but very well, Millard, he is entitled to take it in law. Sixth ground is that the prayer to set aside the award, tribunal did not take into consideration that the present respondent forwarded some blank checks, those 3 crore, Millard, and this finding is
They're actually not blank checks. Those are
no,
the
they were
checks were blank.
checks.
Blank
And
check
this-
is something.
No, yes, I'm sorry, Millard, I stand corrected.
No, the court says, not you. Some blank,
Millard,
blank dated, right?
The last paragraph, the learned advocate for the petitioner could not satisfy me by placing either any legal proposition or judicial pronouncement as to why undated check should not be considered as payment. And thereafter, he relies on entirely authorities to Millard come to the conclusion that loss of profit is something which is payable in law, and therefore the arbitrator doesn't.
What was your counterclaim? We don't find any.
Millard, sales tax declaration forms for the period April, May, June. That was rejected. And that should have been a statutory claim. Non-furnishing of sales tax declaration forms.
No, we don't get the counterclaim, Mr. What was your counterclaim?
Millard, for non-furnishing
understand.
claim, money, Millard, on account which I had to pay on account of non-furnishing of sales tax declaration.
What? So you are not pressing that part of the.
Millard, that I have press করেছি, আমি 34 করিনি.
Good.
Now, Millard, this is so far as this one is concerned. Millard,
Other appeal,
Millard, I have to come back. I could not get myself ready with the.
So we
So,
can
Millard,
hear out
what I
this
do,
appeal.
whatever way your lordship, if your lordship here, because the basic point is the same. But if your lordship wants me to address both the appeals together and thereafter let Mr. Shah.
Would you be able to apprise us at least what is the difference in the your junior may help
My
you?
junior,
No, he may help you. Just what is the basic difference?
Millard, I had
The only difference I have been able to gather
Yes.
is that, well, in the second matter, there was no allegation that part of the supplies means was defective or, my lord, not
Then
useful.
it is immaterial.
That is the only, my lord, difference.
Then it's immaterial. If they feel so, then it's immaterial.
Oh, acha, it's the same thing, my lord, essentially the same thing.
What is the other difference?
But
The
if
sin-
it is in the contract, my lord, it was to supply 1 lakh metric ton per year, not monthly. And secondly, my lord, it says that supply will have to be done, and if OMDC takes out a tender, then respondent would have to participate in the tender and become the highest bid. That was the difference. And secondly, in that case, there were even lesser letters of supply demand.
No, would have to then these tender letters would so
more or
there
less
are other
same.
exhibits.
Other exhibits were more or less same. Apart from the first few letters, the rest are all same.
So then you have a harder case to meet if it was per year.
That case is much better because in the
Why do you say that? Because here Mr. Datta's clear point was that we were to supply
Yes,
7,000 per
yes.
month.
That is per year, but it's the same thing that they would have to participate in the tender and subject to availability. If they don't participate in tender, then subject to availability.
The same thing is here also.
No, it's a different because that says that if OMDC, it's the same, Lordship is right, nearly same.
Exactly same.
Exactly same, but the
Here also, if they don't participate in the, if they participate and become the highest bidder, problem solved. Problem not solved if they haven't become the highest bidder here. So you may up to 7,000, the same clause.
Same clause.
But it is against you, I mean, regarding the 1 year span, because one specific argument in this case was that you had to supply per month. So they couldn't claim bulk together. So that argument of your no, the other arguments remain. But that argument of Mr. Datta that we were to pay month by month in monthly tranches, that argument then goes in.
In that,
that is there.
I need to consider because I had considered that. I need to consider that.
Whatever you say, if you can
But
hear.
whichever way, my learned friend, if he wants, he can answer this because if
Shall you
that's the-
choose? You can hear out this appeal and.
Judgment. Are you going to cite any decisions?
দেখাতাম সব পাইপ দেখাতাম
তুমি দেখো, it's up to you.
10 minutes. So many changes occur in the world.
May I do this, Miller? Let me give me this half of the. Let me see the other contract.
Right.
Then if I find that they are more or less same, then I'll conclude both at one go.
So then should you take it up on some other day, next Tuesday? Then Mr. Shah will hear you after that, or
Yes, my lord. Only my lord, one request. My lord, is it possible to keep it after the 11th?
today we are on.
There are so many fixed matters, my lord, in between. I don't want to be, my lord.
Today is 8th.
8th. Only 3 days, my lord.
No, it has to be on 15th. Because we take up assignment only on that.
That's all right.
Then we'll keep it on 15th. No difficulty. Well, we are doing that then. It will shorten matters if Mr. Datta confines his, even if the other matter is different, the difference will be small. She will be arguing on those differences.
Yes, only the difference.
That will be easier for all.
Because the tenor of the award is the same.
Very well. Heard in part for further hearing on July 15, 2025.
Let your lordship is hearing, my lord, both matters together, my lord.
Yes, both will appear together. That is a better thing. দুটো একসঙ্গে জাজমেন্ট করতে হবে। এই অনিন্দিতা এটা কি আলাদাভাবে অ্যাপিয়ার করছে লিস্টে? একসাথে অ্যাপিয়ার, তাহলে তো কমন অর্ডার। এইটা একটুখানটা আপনাদের ওখানে স্টেপলার আছে? তাহলে এটা দীপঙ্কর এটা একটু স্টেপল করে ততক্ষণ রাখো, এটা 100। Yes, Mr. Yeah. No, but
My lord, my application.
We have for the respondent number 1 out here.
yes.
Restoration application, my lord, dismiss for default.
We have, my lord, just obtained, my lord, my instructions are just obtained no objection and a change. My lord, if we can stand over, my lord, for a week at least, my lord.
My lord, dismiss
We
for
don't
default.
even
You have obtained a no objection. I mean, he has come on a no objection.
My
Waiver, I mean,
has just come into the matter, my lord. They were not there earlier.
restoration within time.
Within time, yes, my lord.
We'll take it up at 2. No, you go through during his arguments. No, restoration. Come on.
May I just indicate then, my lord?
Anywhere, 26/6/25 is
This-
dismissed.
Yes.
It was dismissed in December
My lord,
20.
dismissed for default on 2nd of December 2024. Order is at page 8. This
You
petition,
filed it when?
this petition is filed, my lord. 24th December, this petition is filed. And my lord,
No, it dismissed for default on
2nd of December 2024.
24th dismissed within time. Within
Yes,
30
within
days.
time. And my lord, curiously, my lord, there is also an order of 26th June 2025
Yes.
passed by the learned judge releasing the matter after it was dismissed for default. It's a little,
That does not matter.
no, it does not matter, but
That's why we are saddled with the
yes. So, my lord,
with this
Justice
heavy
Mantha, my
burden
lord,
of hearing a restoration.
we don't have the privilege of, my lord, annoying
No,
Justice Mantha anymore.
The regular determination is with some other bench, or the entire matter has been assigned to us.
This is an assigned matter.
This is assigned matter. Assigned
She
matter.
takes up the
Yes.
assigned matter.
Let us dispose of the restoration application.
Please, my lord.
What is the ground of your absence?
My lord, that the inadvertent error, my lord, nothing more than that.
Engaged in some other court is not a good ground under law, in law.
My
So,
lord,
what novelty is there in this application?
my lord, kindly see paragraph, page 3, paragraph 5 of the petition.
Yes, Mr. Shah, you have to justify your presence.
Yes, my lord, page 3, paragraph 5, my lord.
Yes.
That on the occasion when the matter was taken up, my lord, Mr. Jhunjhunwala, who was there, he had not been attending court for some time, my lord. He had deputed to his junior, my lord, to take the necessary steps during his absence.
But what happened to the junior? You not explained.
My lord, this came on the list.
What
Suddenly, my
happened
lord,
to
of
you?
That
Why
day's
couldn't
old
you?
I was not there in the matter at that time, my lord.
No, Mr. So-and-so had not been attending court, so he entrusted with someone,
Yes,
his
my lord.
junior.
Then page
So what
4,
is the
paragraph
explanation
6,
for his junior's absence?
my lord, that matter appeared suddenly in the list under the heading old matter. It was missed, my lord. Nothing more.
Yes.
This is an inadvertent error, my lord. We bow down, my lord.
We
Will kindly comprehend.
hard learned counsel for the parties, footstep. We find from the amendments made in Can 2 of 2024 that sufficient explanation for the absence of representation of the appellant on the relevant date has been made out. Footstep. Accordingly, Can 2 of 2024 is allowed on contest, comma, thereby recalling the order dated December 2, 2024.
And it is a condemnation of the
Passed in MAT 841 of 2013 as well as the connected application, and restoring MAT 841 of 2013 as well as IA number Can 1 of 2013 within bracket old Can 5429 of 2013 bracket closed to their original file and number.
My lord, there is also a Can 2, which is an application for condonation of delay in filing the appeal.
No, that will come later.
Yes.
No, Can 2.
Yes.
Can 1 must have been that application. Can 2 is the restoration application.
Oh, I'm sorry.
Can 1 must have been.
I beg your lordship.
That will come later. First, let us complete this.
Yes.
Interim order, there was no interim order because
No interim order.
since since there was no subsisting interim order at the relevant point of time, comma, there arises no question of restoring any such order. No rest to cost. Yes. Can 1, are you ready? Then we'll take it up next.
That's very good.
Can 1, the section 5 application,
Yes.
they are record. Let the application, let Can 1 of 2013 within bracket old Can 5429 of 2013 appear along with the appeal appear in the list along with the appeal on July 15, 2025. Next assignment date.
Great.
Very good. Please come prepared of that.
Very good. Affidavit of service.
My lord, affidavit of service I'm handing over. We can make.
প্রথম লাইনে affidavit of satisfaction. Great.
That 8 and 9,
Yes.
there is an office note, Miller, saying Miller that is barred by this delay term limitation. But the fact is otherwise, Miller. A bunch
Yes,
of
there is
civil
a
appeal-
the department has pointed out that
yes, yes,
it's,
yes.
you say it's
But-
not time barred.
Not correct because Miller, the page 108 of the paper book, Miller.
Acha, Mr. Bose, can we take up both 8 and 9 together?
Yes. Yes, because
similar-
yes,
similar
yes,
point.
similar.
Analogous.
Yeah, analogous.
All right.
Miller,
It was a common judgment.
common judgment. And Miller, this is a land acquisition matter of the sale authority. Your lordships have delivered a judgment which stands in your favor.
Acha.
That now, Miller, this was released by your lordships because your lordship at that point of time had no determination, sitting in court number 16,
Again assigned.
again assigned.
Because
Now,
we
my lord,
passed that judgment. Because we passed that judgment, must have been in your favor. No, but Mr. Bosudhi, there is always a risk of the same code differing the next time. You know that.
I don't know that.
It's easier for you to convince the other court that another bench has passed, so we generally follow.
Now,
We'll have a
my lord,
relook at the.
no, my lord. And my lord, today, my lord, I am required to file an application under Order 41, Rule 27 in line with the other matters. My lord, I need 7 days time.
Well, Mr. Bose, please,
But-
should
but
you call him
my
Mr. Bose or Mr. Basu? It differs from court to court. So what do you prefer?
I
So what do you prefer, generally?
There is no preference.
Mr. Bose in the original side and Mr. Basu in the appellate side.
My lord, FAT 160 and FAT 159, page 108.
Mr. Also, please bring a copy of those judgments also so that we can copy paste easily. And bring soft copies also if that suits you.
My lord, these judgments are with me.
Please bring those judgments on the next zero. Learned counsel for the appellant in both the matters which are taken up for hearing analogously, comma, since they arise from the same, from a common judgment, comma, seeks a week apostrophe adjournment to file applications for production of additional evidence. Full stop, such leave is granted. Let the matter be listed under the same heading on July 15, 2025. Full stop. Leave is granted to the learned advocate for the appellant to mention the applications, comma, as and when filed, comma, for enlistment along with the appeals.
Deeply obliged.
Please file it very soon, Mr. Bose, so that it can be mentioned within this week and we can put it in the list next.
এই সপ্তাহে করে দেন। Deeply obliged.
Yes, correct.
May it please your lordship. Here I am for the respondent.
Right.
I have Mr. Bachawat is senior to me professionally.
Separate?
Mr. Bachawat, Ranjan Bachawat is senior to me professionally. So he is to today, he's joined. If he would like to make submissions, he couldn't come because I think the rains are on his back because of the I will take some time. Maybe they can rejoin.
Sometime means Mr. Bhattacharya, sometime you
Then it's
get a clue.
Lord, Bachawat, what do you say?
Yes,
Lord,
Mr.
there's
Singh,
waterlogging outside my house.
well,
so I
absolutely,
cannot
absolutely. No
make it.
difficult.
Lord,
No
this will perhaps require, Lord, Lord, I don't know if your lordship takes it up. Lord, I'll need to be there physically. So if Mr. Bhattacharya makes his submissions today and your lordship permits me to make it on the next day, Lord.
Yes, yes, absolutely, absolutely.
Bachawat, Mr. Bachawat will argue today and next day maybe. The indication.
So, Mr. Bhattacharya, try to make it as short as possible.
Yes, but I will.
Yes. What is the?
But there are, my lord, two applications.
Right.
My lord, that also needs to be considered because one is my application under order, the appeal and the applications. Order 41, Rule 27. My lord, certain documents which are actually their documents filed before the trademark registry. It is not something, my lord, which I have produced or manufactured or anything. My lord will kindly take
But what is the explanation for not producing in the court bill? What are we taking up? I mean, what is the impugn order?
My lord, the impugn order, my lord, it's a suit for passing off. Though they say it's a suit for infringement and passing off, I will show it is a suit for infringement. It's a suit for passing off.
Passing off. So in that
restrained,
yes.
Permanent. This is my bottle.
1 minute, Mr. What is a permanent temporary injunction or ad interim?
My lord, the temporary injunction order 39 has been disposed of.
Passing off.
My lord, it is the liquid inside. So bit careful. This is what I have been
See
restrained.
from here. We don't want liquids on
This
us.
is what I have been restrained, and this is their bottle. And in fact, my lord, when the appeal was moved, the appellate court, my lord, made an observation. If I am willing to change my label, your lordship will kindly see that appellate court's observation.
Appellate court means this is the appellate.
Initially, when the appeal was admitted, my lord, it is can number 3 of 2024.
Yes,
it's a petition affirmed by Mr. Ramesh Kumar Agarwal in sometime in August 2024.
Yes.
If your lordship kindly takes the order of the appellate court, which is at page 8. My lord, directions were given.
Yes.
And my lord, at page 10. At page 10, last paragraph, on the basis of submissions made by Mr. Mitro, at the time of pronouncement of this order, leave is given to the appellant to take out an application to seek leave of the court to manufacture, market and advertise oil in plastic bottle with a modified trade dress. So this was my trade dress. Now I have changed it to this, which your lordship will find at page 11 of that application.
What is the original one?
My lord, the original is this. This is empty. This is empty.
তেলটা না পড়ে যাবে
There is no oil in it.
জজকে তেল দেওয়ার অপরাধে Which is the changed one?
Now this is the changed one. This is theirs, this is ours.
Changed বোতলটা দিন বোতলে বেশি You have changed the color.
Absolutely. Blue.
দূর থেকে বোঝা যাবে
And this is theirs.
Yes. You just keep it at a distance. You keep it in your hand. We'll see from here. Din to Ferat. No, you keep it in your hand so that we can compare the two. Your current one and theirs.
Yes. And now, my lord, in the order 41, rule 27, your lordship will kindly see can 2. This is my order 41, rule 27.
Yes.
What I have annexed. But there were certain disclaimers given by them before the trademark registry. But your lordship kindly takes page 8 of this scan 2.
Yes, page 8.
My lord will kindly see goods and services class 29.
Mm-hmm.
But there is one difference which I should first highlight. Theirs is an edible oil under class 29. I don't know whether your lordship had food cooked in coconut edible oil. Kerala, I had.
Yes, in different other places of India, I have had.
Mine is a coconut oil. His is an edible. It's a Ayurvedic hair oil. His is an edible oil. The bottle in which he is selling his hair oil is this.
That's very well.
This is an edible oil.
All right.
Now, my lord will kindly come to page 8. These are documents which have been taken out from trademark registry. My lord, I did not know they were into selling cashew nuts and fish, because the goods and services description your lordship will see is very wide. Now, my lord, this condition: registration of this trademark shall give no right to the exclusive use of all other descriptive matter appearing on the label. So what they have a registration is over this label, this red label they have.
Yes.
So they cannot claim monopoly over coconut tree or a rising sun or whatever are the descriptive contents of this label. They can claim it as a whole, and that's what is the purport of the Act, section 17. I will show it to your lordship. They completely suppress this. Now, my
the
lord,
trademark was relating to what?
My lord?
The trademark was relating to what?
This entire label.
But that contains the coconut tree and the
Yes, but
in a particular fashion.
It will not give right to that. It will not give right to that.
All right. All other descriptive matter appearing on the label.
Yes, my lord will kindly take, because if I am selling coconut oil,
yes,
there has to be a coconut tree. I cannot be a banyan tree. Trademark sector.
All right.
My lord will, apropos this, your lordship will kindly take section 17 of the Act. 17(1).
Yes.
When a trademark consists of several matters, its registration shall confer on the proprietor exclusive right to use the trademark taken as a whole. So it is as a whole, not just coconut oil or the coconut tree. It is as a whole.
Not a part of it.
Not a part of it. As a whole, he can use it. Now, my lord, what I have disclosed in my application under Order 41, Rule 27, he can, my lord, he can, over the coconut tree, if your lordship looks at 17(2). For that, he needs to make a separate application, which is not there. Notwithstanding anything contained in subsection 1, when a trademark contains any part which is not the subject matter of a separate application by the proprietor for registration of the trademark, or which is not separately registered by the proprietor, or contains any matter which is common to trade or is otherwise of a non-distinctive character, the registration thereof shall not confer any exclusive right in the matter forming only a part of the whole of the trademark so registered. He could have easily got this
separate trademark regarding that portion.
Yes. So it has to be as a whole. The Shalimar is registered. Nobody disputes Shalimar, my lord. My lord, as a matter of fact, your lordship will recall, in our younger days, it used to come in a green metallic tin box.
Yes.
And in winter, it used to
froze.
Yeah. And it had to be under a heater or something.
Or in some hot
yes,
water.
put some hot water.
Hot water would be better.
Yes.
Yes.
Now, my lord, now with this materials, it does not happen because they contain chemical ingredients.
Right.
Now, my lord, kindly comes to page 10. Now, this is the examiner's report at page 11. Now, at the bottom of the page, this is the examiner's report as to why he should refuse. Now, if your lordship kindly comes to the bottom of the page, handwritten, no exclusive right to use device of the container appearing on label. That's why the trademark registry refuses. Now, my lord, kindly comes to page 14. At the bottom of the page, they give it up. They give up. At the bottom of page 14, registration of this trademark shall give no right to exclusive use of all other descriptive matter appearing on the label.
So this is in the context of page 11, you are saying.
But there are various. So, my lord, there are various
Don't look at us. Look
registrations.
at him. Don't look at us. Look at him.
He's saying it to continue. Maybe.
He may be lying. We don't know. We don't take any responsibility. We don't take any responsibility. No, not at all. We don't agree with that. Yes.
So, my lord, there are various applications.
This is not a college reunion, Mr. Chatterjee. Please let him continue.
There are various applications they have made because they change this. Instead of 3 coconuts, they make it a single coconut. Or
don't give them new ideas.
So they keep on. So it gives the trademark registers the opportunity, the trademark attorneys, to make money. So, my lord, now coming back to the paper book. The suit is, my lord, the plaintiff has to be seen. What ineffectively has been done is, I have been restrained from using the shape of the bottle as well. Now, my lord, before I come to it is not just me. Others are also using, as a matter of fact, this device. There are other brands. This is me. And these are other companies. This is some Boidyo Buti. This is Sri Balaji. This is Sampurn.
Lord, these are nowhere on record. My learned friend is showing this.
Of course, these are in
not before the trial court. If you are saying so, please show the paragraph in your trial court pleadings, Mr. Bhattacharya.
We don't look at the borders.
I will. If since he has disputed it, it was there in the affidavit in opposition.
Is served. Your purpose is served, but we don't look into it.
No. I will show it was. It was there in my affidavit in opposition.
Oh, acha.
Yes.
Very good. So we have got. We get an idea of what you are saying, Mr. Bhattacharya. Yes.
But it's at page 713 to 717.
Okay.
Page 713. What is the volume number?
71, my lord, volume number 4.
Thank you.
Baba, ki chapiechis. 713 to 71.
These very bottles, Mr. Bhattacharya, which
yes, my lord. I can get the original.
Need not very well.
Original.
Yes. But there are so many green ones and blue ones. You are showing only yellow ones.
Yellow ones. My lord, 713, your lordship will kindly see it's Sampurn, yellow one. 714 is Balaji.
Oh, yes. Right.
715 is Boidyo Buti. So this was very much a part of
there were at least 3 yellow bottles. Right.
And my lord will kindly also see page 716. How they use it. They cannot
I
claim
stand
monopoly.
corrected. If it's there, not I stand corrected.
Yes, Mr.
716, how many colors they use? They cannot claim the entire vibgyor or a combination of the vibgyor which is white, or the absence of a vibgyor which is black. Blue, coconut oil Shalimar, green, then green, green.
This
green,
is for the
these are
same trademark, with the same trademark.
My lord, your lordship, I don't know, my lord. Mr. Bachawat and I have a vice. So there are various sub-brands of ITC. Some comes in red color, some comes in white color, some comes in golden color.
There are other colors also. We also suffer from that vice.
Yes.
So
No
difficulty on
they cannot claim monopoly over yellow.
Color,
all shape and sizes.
Color, shape of bottle, these they cannot claim.
They cannot.
Monopoly. Very.
Unless it was registered as a shape of goods. I will come to that, my lord.
Yes, that is not there.
Now, that is the next point I will come to. Now, my lord, Trademarks Act, my lord, your lordship has the Trademarks Act. Narayana.
Yes, you hand it over.
Now, before this 99 Act, the law which held the field in relation to trademarks was the Trademarks Act 1958. Your lordship will kindly see 2J, the definition. Your lordship will not find it over here. 1958 Act, if I may hand up. Definition of mark. If I might just read and hand up, my lord, mark includes a device, brand, heading, label, ticket, name, signature, word, letter, or numeral, or any combination thereof. It did not even use color combination or shape of goods.
Yes. What is the difference with the present definition?
Now, my lord, will now kindly come to 2M. Now it has included shape of goods as well as combination of color. But you have to register it as a shape of goods.
Right.
So lordship will kindly come to M2M, my lord.
Yes, yes.
And this arose because of a very particular case, which is known as a Jeff's Lemon case. I'll just tell your lordship what that case was all about. My lord, mark includes a device, brand, heading, label, ticket, name, signature, word, letter, numeral. Now they have introduced shape of goods. Packaging or combination of colors.
Yes.
This is also included, but it is to be a combination of colors. For example, a Duracell battery, gold and black. Once anybody looks at that battery without even looking at Duracell, that gold and black, one can identify. But just looking at a yellow bottle.
Then they had to have a separate trademark on that.
Separate trademark. And I will take your lordship through their trademark applications. Now, why this shape of goods? Because, my lord, even now the registries are being faced with various types of difficulties. For example, my lord, somebody uses a very expensive perfume. Smell mark is not included in the definition. But it is capable of identifying, because the purpose of trademark is to identify the source. So if somebody wears a perfume, and especially Mr. Chatterjee is not here, who has a penchant for very expensive perfumes.
Identifying a smell is also, it would be,
it
we can only imagine what the court should have to go through then.
Yes. So, my lord, so Jeff's Lemon case, what happened was somebody was selling lemon juice in
Just to interrupt, Lord, just to interrupt, perfumes have now started getting registration abroad though. In the
Yeah,
Europe.
abroad.
Oh,
abroad.
oh, acha,
Smells.
perfume, the
Smells.
fragrance.
Smells.
Oh,
Yes,
yes.
smells.
oh,
Smells. Not per se for a perfume perhaps, but to identify goods.
all right. Thank you, Mr.
That's the
I didn't
new
know that.
spin.
Yes, my lord, I have written an article very recently on that. So,
Acha.
for example, my lord, sound.
Yes.
The moment I am in this room and somebody in the next room turns on Netflix, there's a particular sound.
Hmm.
So one can make out that
The
somebody has
sound, if
turned,
it's a jingle or something like that, I mean, it can
No.
be classified.
my lord, like Metro Goldwyn Mayer, that roar of the lion.
Yes.
The moment I put on a movie,
It's not exactly music. I mean,
Not exactly
the
music.
line, yes.
music will come under the Copyright
The
Act.
composition,
It's
yes.
composition. That will come under the Copyright Act. That
All
will not be
Yes,
put
that,
under
that is
the-
what we are thinking. But you're right.
My lord, so
There are
it's just,
certain shades between a music and the sound. I mean,
yes, my lord. So, my lord, so there, my lord, the question before, I think it was either the Court of Appeal or House of Lords, I don't remember. I'll get the judgment on the next day. So one person was selling lemon juices in containers shaped as lemon. So the question arose whether that shape of goods can be used as a trademark to identify the source. So the House of Lords came, no, yes, it can be. It can be. And that's why our legislature, in its wisdom, has brought in shape of goods within the definition of trademarks under 2M.
all right.
Now, so before 2002, there was no question of shape of goods. There was no question of shape of goods.
Right.
So their contention that they have been using this from 1945 is a complete misnomer. Now, also one more section. My lord will kindly take also section 159, which is the repeal and saving provision, because they have relied on various certificates
Yes.
which are much prior to amendment of this act. My lord, subsection 3.
Yes.
The provisions of this act shall apply to any application pending at the commencement of the act or to proceedings and to registration granted thereto. Now, subsection 5, notwithstanding anything contained in the act, where a particular use of a registered trademark is not an infringement of a trademark registered before the commencement of the act, the continued use of the mark shall not be an infringement. So if I have started using it prior to 2002, it will not be an infringement either.
Very well.
Now, my lord, I will take your lordship through the plaint once. I will trouble your lordship with the plaint, because what I have been injuncted is the shape of goods. Because, my lord, in this label, I am not writing Shalimar. I am not trying to deceive anyone into believing that my goods are emanating from Shalimar.
Most importantly, they don't have a trademark on the shape, color combination, nothing.
So I am using my source. I am clearly indicating my source. At best, even if I take his case of passing off, I will be protected by Durgadat Sharma, because I indicate my source. I'll come to that judgment also.
See that of their registration at 180, they say that they have the entirety registered.
Now, your lordship, the plaint starts at page 46. How? Page 46, volume 1.
Alert থাকতে হবে আপনাদের।
না, আগে প্লেনটা দেখাই।
ট্রেডমার্ক একটা নিয়েছেন, এটা তাহলে ফেরত। Yes.
Now kindly looks at page 48. Paragraph 4. I did not know that plastic bottles existed in 1945. In or around the year 1945, the plaintiff conceived of and adopted a novel artistic get-up of its label composite mark for use on its containers, metal and HDPE. HDPE is basically plastic. High density, something polymer, something, my lord, I don't know. Now, my lord, your lordship will find his registrations, which he has stated in paragraph 5 at page 49. In order to obtain statutory protection, the plaintiff from time to time file necessary applications for registration of its trademark with the distinctive artistic get-up and overall trade dress. My lord, that would be this entirety of this. Under the Trademarks Act 1999, could not have been 1999 because 1999 Act was not in force as on the date of registration mentioned below. And in respect of various goods in class 29 and other related classes and obtain registrations in different forms, particulars whereof are, my lord, will kindly look at it, all edible oils, not coconut oil. I am in a different I am in a different class. I am in class 3 is in class 29. And it could not have been shape of goods because shape of goods was excluded under the 1958 Act. Then again 88, and I will trouble your lordship with the registration certificates once. Edible coconut oil for sale in state of Assam, Bihar, such and such. Now, my lord, 1997, again edible oil. Then, my lord, his 5th registration comes, that is also device, that is also not shape of goods. And possibly, my lord, this act was notified in 2003, though it's 1999 Act, but it was notified in
2003 apparently.
It was notified in 2003.
Whether the entire act was notified in 2003? Let us just check.
I think so.
Probably that we saw somewhere. Yes.
I think it was notified into. I
yes,
will check.
15th of September 2003.
Yes. So even his 2002 registration couldn't have been in respect of. And all are edible oils. So there couldn't have been any infringement.
And yours is hair oil, you said?
Mine is hair oil. They also manufacture hair oil, but their bottling.
That's it. Yes, that you should.
But their bottling is this.
So your classification is under?
Hair oil, class 3. Because I'll tell you a lordship why. Edible oil can be used in food, but mine contains Ayurvedic extract with amla.
The traditional Bengali question, Khaya na mathay de, has been answered in classes 3 and 29. Yes. So it's a different category altogether.
Different category.
Right.
Absolutely.
Class is also defined.
Absolutely different.
Right.
Now, my lord, paragraph 8. By virtue of continuous, uninterrupted and extensive use of the said composite mark with the aforesaid distinctive artistic get-up, color combination, style of writing arrangement for 78 years, the said trademarks and its artistic get-up. Nowhere they are talking about shape of goods. Subject to correction, except 3 places in the plain, nowhere has shape of goods been used, nor even in their prayers.
So the injunction has been granted in respect of shape of goods only or the color combination?
Shape of goods, color combination, everything in its entirety.
But they speak about color combination in para 8.
Paragraph 8, my lord, only 3 places, and I will show that. Only 3 places they use the word shape.
You are more on shape, color combination. You're not on color combination because your color combination also seems to be similar.
My lord, his
Now you have after alteration, it's blue.
but
Yellow
but-
background
no,
remains.
my lord, this is yellow, my lord. One cannot claim monopoly over yellow.
No.
Combination of colors. His is, my lord, red, yellow. Mine is, my lord, a maroon and an yellow.
Red and maroon. Many of us would be marooned in distinguishing the two.
That's how. That's
Most of us, in fact.
That's why I have
Unless you are a supporter of a particular club, which I am, but yellow is also there. So,
Well, but now I have changed it to blue. There cannot be any confusion. Red and blue.
right.
Now, my lord, paragraph 10.
Yes.
By virtue of extensive use and publicity in various media, the said composite trademarks with distinctive artistic get-up have become popular amongst consumers and general public. We don't dispute the fact that Shalimar is actually a very popular brand.
That's why they choose passing off as
passing. No, they have
because
an order for infringement.
Infringement maybe
They have got an order for infringement. Now, my lord, paragraph 12. They have said why their brand is so popular. From time to time, the plaintiff, for the purpose of advertising and marketing its products under the aforesaid trademark, has engaged the services of various well-known celebrities, including Hema Malini, who is also the brand ambassador of the product. Now, my lord, they say in paragraph 18 that they had filed against some other entity. My lord, will kindly look at this. In or around, the plaintiff was constrained to file 5-1 the Learned City Civil Court against 1 Z Hygiene Products for infringement. My lord, it was a passing off action. Copyright, passing off, composite, mark, label. And I will show the trademark registry manual how a shape of goods is to be registered. There is an elaborate process described in the manual about registering a shape of goods. My lord, then, my lord, very interesting, they put us on notice, they give us a cease and desist notice. We file caveats before the commercial court, even in Calcutta High Court. It was extended twice. The day, it was around 14th or 15th of August, the caveat expired. The next day, they went hurriedly before the commercial court at Alipur and obtained the ex parte interim order. Prior to that, they initiated FIR. We have filed a quashing application and there is an order of Justice Chaudhary, Vivek Chaudhary. I will take your lordship to that order.
now it has been made absolute.
Now it has been made
Against
absolute. Yes, after. Yeah.
Contest.
But this is the conduct. So they could wait for 6 months while my caveat was pending, and suddenly the day the caveat expired, the next day they rushed to court and obtained an ex parte interim order and shut down my business, which has been shut down for the last 2 years. Now, my lord, paragraph 20 at page 58.
Yes.
Sometime in and around 3rd week of July 2022, the plaintiff was shocked to discover that the defendant has adopted a deceptively similar and or identical trademark, trade dress, get-up, artistic work in respect of its coconut oil and has been using deceptively similar and identical bottles in green and yellow color to sell its product, that is inferior quality coconut oil. The said adoption by the defendant of an identical and or deceptively similar trade dress trademarks as that of the plaintiff is ex facie dishonest, mala fide, and has been done by the defendant solely to pass off its inferior quality coconut as that of the plaintiff in order to create a trade connection or association with that of the plaintiff in the minds of general public. I'll not trouble your lordship with that.
No,
Now,
initially yours were green and yellow also.
no, mine is
Before red and yellow? Aaj this.
this. Acha, green bottle da dekha. Green bottle da dekha.
Green and yellow, they say.
Yes. There are several kinds of bottles. As I have shown, they are using several kinds of blue, black.
This was your initial.
This was my initial. Green also. ওদের original green টা দেখা? তোদের original green টা আছে? This is our.
Yes.
We can change it. We can change the color scheme over here.
You're also selling that now.
No, 2 years after injunction, my lord, we are not selling.
No, after injunction, I mean.
No, we are not.
Due to the injunction, you are not selling that. But
Accordingly, on or about, my lord, page 59, accordingly, on or about July 23rd, 2022, the plaintiff caused its advocate to issue a cease and desist notice inter alia calling upon the defendant to immediately cease and desist. A copy of the CR. On September 7, 2022, the defendant through its advocates replied to the plaintiff's cease and desist notice by inter alia stating that the impugned trade dress is not so similar and there are other manufacturers who have been using identical and similar trade dress. On September 10, the plaintiff caused its advocates to reply to the said communication dated 10 September, inter alia reiterating its earlier stand to cease and desist from using deceptively similar identical trade dress. After receipt, the plaintiff under bona fide impression that the defendant has stopped such and such. Now, paragraph 26. Pursuant to the complaint dated 10th March 2023, FIR was lodged with the Chitpur Police Station under section 63 and 65 of the Copyright Act 1957, read with section 120B and 420 of the IPC. Thereafter, a raid was conducted on April 5th, 2023 between 16:55 on the ground floor of such and such, found yellow plastic. Mine was basically yellow, 15,000 yellow plastics. Plastic color empty boxes. It was mostly yellow. Accordingly, a notice under 41A, my lord, page 61, was issued by the concerned police authorities on one Govind Modi, who claimed to be the manager. Thereafter, on 12th April 2023, the defendant made a representation to the concerned police station in response to the claiming that it has been using the packaging since the year 2017 and that was not identical or deceptively. A copy of the representation. Thereafter, sometime on or about April 18, 2023, the defendant filed its revisional application under 482 before the Honorable High Court for quashing of the proceedings under such and such pending before the, on May 10, the Honorable High Court at Calcutta admitted the civil revision and inter alia directed the investigating officer not to not take any coercive steps against Govind Modi. In fact, my lord, this has been disposed of and the FIR has been quashed. I'll show that. Now, my lord, this has been going on from September 2022. In or about the second week of August 2023, in fact, they obtained the ex parte order on 16th of August 2023. 16th, was further shocked to come across a website being www.kmpayurvedic.com, which is owned and controlled and operated by the defendant, wherefrom it appeared that the defendant is still advertising, marketing, and selling its inferior quality coconut oil with the impugned trade dress and in identical looking and, my lord, here they use the word shaped. Here they used the word shape for the first time. Yellow and green color bottles. The plaintiff, after causing searches, came across the plaintiff's social media page on Facebook, being KMP Ayurvedic, wherefrom it appears that the defendant is still advertising, marketing, and selling its inferior quality coconut oil with impugned trade dress and in identical looking and shape. Here, for the first time, they come up with the word shape. Yellow and green color bottles. In fact, a link is provided on the said page for placing orders of the defendant's inferior quality coconut oil with impugned trade dress in identical looking and shaped yellow and green bottles. Now, here comes shape. The social media, the said social media page of the defendant and the aforesaid website are interactive website through which the defendant has been advertising, marketing, and selling its inferior quality coconut oil with the impugned trade dress in identical looking and shaped, both within and outside. Now, paragraph 33. From the aforesaid, it is evident that the defendant is passing off its inferior quality oil as that of the plaintiff by slavishly copying the entire trade dress of the plaintiff using color yellow, artistic getup, and shape of bottles. My lord, even if he is claiming right over the shape of bottles, he has to give his date of adoption of shape, on which date he adopted this shape. My lord, the 5 principles of Lord Diplock in warning, my lord, I will rely on that. My lord, that has to be established in a case of passing off. The defendant, in order to mislead the general public, have used the name KMP Ayurvedic. If my intention was to deceive public, I would have used Shalimar or something akin to Shalimar. Instead of Shalimar on level, but nevertheless has copied the entire.
Could have just changed the gender of Shalimar, suppose. Yes, Mr. Otis, please.
The plaintiff states illegal, my lord. These are the plaintiff. Now, paragraph 35.
Yes.
Nothing to show that they have been, because I will show that the documents which they have produced does not support this. The plaintiff, paragraph 35, is the prior user, adopter, and proprietor of the registered trademarks and the trade dress, and has been using the same for advertising, marketing, and selling in a unique shaped green. My lord, could not have in 92-93, because shape, it could not have been registered in 92-93, because the definition of mark did not include shape in 92-93. So this is a false statement.
They say they were using the shape.
No, my lord, proprietor of its registered trademark and trade dress, and has been using in unique shape bottles.
Using, so they distinguish registered trademarks and trade dress, and has been using unique shape.
I will show no documents to support this. It's contrary to the documents which they have disclosed.
You will also have to cover passing off in your arguments, because trademark, strictly speaking, you may have a better case.
Infringement, yes, I have a better.
Infringement, you have a better case.
Yes. Now, my lord, page 64, very unique. They're comparing my bottles with my bottles. My lord, will kindly see KMP.
Yes.
The test would be comparison between his bottle and my bottle.
Yes.
Now, with identical looking and shaped colored containers bottles by defendant by selling its inferior to the plaintiff's registered trademark, getup, label, and artistic work. But my lord, so far as even to get an order in passing off, he has to say that this is my shape, this is unique to me, and I am entitled to an order of injunction. Without that prayer, could the court have granted that relief? That prayer is not there. Now, my lord, page 66. Because everywhere the plaint is replete with trade dress, get up, shape of goods only in 3 or 4 places. Paragraph 37. The defendant is inter alia engaged in similar business of manufacturing, marketing, and selling of coconut oil. The plaintiff was shocked to discover on or about 2nd week of August that the defendant is still continuing to infringe and pass off its inferior quality coconut oil by dishonestly copying with the malafide intent the distinct and unique trade dress, including the look and shape of bottles, containers of the product. They're aware of it because they have no right over it. But all shape of goods cannot be a trademark. Something which is distinctive, like a contour bottle of Coca-Cola. So that's what Jeff Lemon's case says. It has to be unique and distinctive. But these bottles which are manufactured by 10 other manufacturers also, what distinctiveness is there? Malad, if I take out this label, will anybody be able to, this I remove, this Shalimar, will anybody be able to say this is the source of this edible oil, that it is Shalimar? If I take off the wrapper of Coca-Cola and look at the contour bottle, one can say, oh, this comes from Coca-Cola. Because it has become so distinctive of them. The defendant, despite being fully aware that it has no connection or association and is not authorized to use the unique and distinct mark trade dress. And what do they give, my lord? At page 38, they give this. They use this. They do not use shape of goods. They use this. My lord, will kindly see the comparison at page 66. Now, paragraph 39. Subsequently, they go on and do that. The plaintiff was shocked and surprised to discover that the defendant has been wrongly and illegally using the unique distinctive mark trade dress, which forms the most essential distinctive features of the registered trademarks of the plaintiff, as part of its trade dress mark with insignificant words came.
Mr. Bhattacharya, they argue the pleadings are repetitive. You need not place everything.
My lord,
because mostly, I mean, we have got your point. They also include
now,
this.
I will straight away take your lordship to the prayers in the plaintiff.
Right. Page 87.
But I need to show the registration certificates.
Yes, you have to. Registration certificates we'll look into.
Your lordship, excuse me for 2 minutes, my lord. I'll just...
Yes, please.
May your lordships please the prayer, your lordship. In the meantime, Mr. Bhattacharya will come. Page 87, your lordship.
87, yes.
The plaintiff therefore prays for leave under order to Rule 2 of the Code of Civil Procedure and claims. Oh,
no difference.
A decree of perpetual injunction restraining the defendant, it men, servants, agents, assigns, distributors, directors, dealers, licensees, subsidiaries, or anyone claiming on its behalf from using, manufacturing, offering for sale, advertising, marketing, promoting, and selling in electronic media or interactive websites, or otherwise dealing in goods bearing the impugned trademark, trade dress, no shape of goods, and there is not a word of infringement, either in isolation or in conjunction with any other mark. And my lord, what they set out is the device, not the shape of goods. With the plaintiff's registered trademark, trade dress, or its distinctive get-up, color combination, packaging in any manner whatsoever.
The original must have been in color. So these are, the right hand side is green and left is yellow. I mean, the darker one is green and the...
My lord, I will just...
Must be that.
Yes.
Must be the darker one is green and the lighter one is yellow. Very.
A decree of perpetual injunction restraining the defendants and or its men, servants, agents, assigns, distributors, directors, such and such, from passing off its goods under the impugned trademark trade dress by manufacturing, offering for sale, advertising, marketing, promoting, and selling through electronic media or interactive websites, or otherwise dealing in goods bearing the impugned mark trade dress. The emphasis is trade dress, either in isolation or in conjunction with any other mark which is identical and or deceptively similar to the plaintiff's trade dress.
And they use the same photographs. So
use the same photographs.
Infringement allegation, at least in the we don't find an allegation as such of infringement, rather passing off. Passing off is there in prayer also. Prayer.
They do not use the word shape of goods.
No, not shape.
They use trade dress.
Trademark stroke trade dress. Yes.
So they have to claim distinctiveness in this shape of goods. They have to establish the 5 rules laid down by Lord Diplock in warning, which they have not done. Not
Mr. Bhattacharya, is the impugned order longish?
It is a bit longish.
What were the injuncted? What were you injuncted from doing actually?
We'll
Let us just have the ordering portion and then we'll come back. That will give some context to the arguments.
No.
So we'll look into the memo. We can look into the memo.
Yes, memo.
We'll just see the ordering portion at least.
Volume. It would be in volume 5.
We have the memo, so we'll just look into that. You can take it.
My lord, 826.
Yes. The list
B is the order.
You can refer to the paragraphs of the order, para 16 onwards.
Yes, my lord. My lord, in fact, it is an unreasoned order.
That will go into later. We'll just look at
834, my lord, page 834. Before that, my lord,
just come to paragraph 16 of the order, please.
Considering the aforesaid principles of law, in my view, the label of the defendants are undoubtedly quite similar. The color combination and the get-up are very close to each other. Hence, it would not be possible for a common man to decipher the two products. In any event, unless and until the suit is tried in proper evidence, it would not be appropriate for me to allow the defendant to use those labels which would create immense prejudice. Plaintiff, in my view, has established a strong prima facie case in support of their prayer for interim order. The balance of injunction is in favor of the plaintiff in passing an order of injunction. In result, the application succeeds.
So all the prayers are allowed.
Plaintiff has filed an application in
the prayers in the injunction application must be similar to that of the plaintiff.
Yes, but I will show the injunction application also.
Must be same. Yes. There's a difference.
Order is confirmed. Addendum order is confirmed.
This prayer B.
Oh.
But the effect is to stop my shape of goods also.
No, we'll just check up.
My lord, that's at page 544. If your lordship kindly takes page 544, volume 3. Plaintiff. My lord will kindly see the first line of the order.
Yes.
The plaintiff files a suit for infringement and passing off and for infringement of copyright such and such requisite. Let it be issue summons accordingly. It appears from record. My lord will kindly see the date of the order, 16th of August. Yes. It appears from record that there is a caveat against the plaintiff by the defendant herein on 16/5/2023. Now, my lord, paragraph 3, this is the contention of the plaintiff.
Page 549 B is granted as this.
Yes. Paragraph 9, considering all, it is viewed that the trade dress and or get-up of products of the plaintiff and defendants are tweedledee and tweedledum, which creates a sheer doubt. As such, the right of the plaintiff should be protected. Decision, the court is of the infringement and passing off. Fruitful to grant necessary prima facie case. Appearance in the prayer B is granted. Now, my lord, to claim monopoly over shape, you have to have it registered as a shape of goods.
The shape has not been granted, Mr. Bhattacharya.
That is, my lord, makes it clear. Makes it clear that that will not preclude me from using the shape.
You are agreed with the shape.
Yes, my lord makes it clear. And with this changed color combination, I have no grievance whatsoever.
Because the injunction has been granted only.
But this has been what has been construed. And I have been stopped.
Trade dress.
And I have been stopped by this. My lord makes it clear that I will not be precluded from using this shape and with this changed color combination. Because this has nothing to do with this red.
What according to you, Mr. Bhattacharya, is trade dress in its connotation?
Trade dress is this.
No, what do you mean by trade dress? What is the definition of trade dress?
Trade dress is something, my lord.
What's the difference between a mark and a dress?
Dress is, my lord. It includes color combination, breakup, and everything.
Do we get it somewhere in some judgment or somewhere?
Yes. I will show from Narayan.
Because it entirely boils down to what is the ambit of trade dress.
I will just come to that, my lord. Narayan. Yes. I have just handed up Narayanan, my lord, to your lordship, my lord. May I just take back that Narayanan?
Narayan Ferudidin. Nil. Yes.
One note act to them.
Act Narayan.
Trade dress is basically, my lord, the embellishment on a packaging.
Character কি আছে? কি নারায়ণ একটা আছে? আর কি আছে এখানে? আর কোনো বই আছে?
My lord, this is a trade dress. This is a trade dress.
Yes. What is a trade dress?
The bottle also.
That label.
Trademark is very wide. Trademark, that's why includes shape of goods.
My lord, I take it he's sticking to this argument. That trade dress is restricted to the label. If that is his case,
That was what we are wondering, because what you're showing is the
let him
label.
say that the trade dress will not include
What do you
everything.
mean by this is the trade dress? We cannot put it in words in our judgment. What is a trade dress? You have to establish that. Because Mr. Bhattacharya, it hinges on this passing of trademark and trade dress.
Because the act does not define what is a trade dress.
Precisely. That is why we are asking.
The act says a device, brand, heading, label, ticket, name, signature.
So we can look into the registration certificates also, so
Yes.
that we get an idea of what they have
Now,
got.
my lord, that would be
easier
That would be easier, my lord.
Yes. Because
My lord,
what we can
kindly now takes volume 1, which has all their registration certificates one after the other.
Correct. Yes.
None has been sought to be registered as a shape of goods.
Trade dress is there. I mean,
No. Only device. And I will show what is the definition of a device.
So it starts from which
Page 149 is their registration certificate.
149.
149, volume 1.
Yes.
My lord, under the old Act, 58 Act, my lord, there were two kinds of registration. One which is distinctive in its nature and which has become distinctive by user. For example, my lord, Kit Kat. It is not a common English word. Kit Kat would have been registered in Part A, which would have given a better right. But something like, what would I say?
No, which is equated with the product. Do you mean that?
No. Something which is distinctive. My lord, it is not a
Generic.
common dictionary word.
Not a generic thing.
It's Kit Kat. But if I use chocolates, it might over the years become distinctive with the use.
Cadbury, like chocolate is equated with Cadbury.
Cadbury also is not a common English word, my lord.
No, that is what we are saying. But
Cadbury is not
Cadbury is equated with chocolate sometimes.
Yes. Photocopy.
Yes.
So, my lord, this was their first certificate at page 149. And what is being registered is in Part A. It is in 1961, but what is registered is at page 150. That is the, my lord, I have to take your lordship through this entire. Now, my lord, page 151 is a device mark.
Yes.
Your lordship will find proposed to be used.
Right.
And what is the device that your lordship will find at page 152? And they had given disclaimers that they will not claim monopoly over the descriptive materials over here, which would be coconut, sun, moon, whatever.
That's not there in this page 152.
No, they have concealed it. They have suppressed it. That's why I had to file that order 41 rule 27.
It's the same document. I mean,
My lord, maybe the different trademarks. I will.
Must be different treatment. They cannot.
It remains the same. I will just
No,
ask.
at
my
least
junior-
in this trademark, that is not there. That
I
disclaimer is
will
not
tell your lordship which trademarks are there.
maybe some
একটা
different.
comparison করে দে না এটা comparison করে দে কোনটা আছে now my lord the next one
Lord, your lordship may have noticed something strange at page 152. Lord, the spelling of coconut there.
Yes. Right.
coconut
Cocoa. But then that also has to be your name is different. Your name is the usual coconut. Your trademark, Mr. Bhattacharya?
Oh, ours is also usual coconut in all the rest. I'm just showing your lordship that sometimes mistakes are also probably there.
Yes.
Or maybe the spelling of coconut has evolved over time. I'm not very sure what it is.
Maybe.
like your lordship now if your lordship uses the American English your lordship types color it will automatically correct as COLOR. It is not COLOUR.
So there are subtle things also. Presently we use equate with currently. Presently does not mean currently. Presently means immediately hereafter.
Yes.
Presently I'll be doing something. But we regularly, Supreme Court judgments, our judgments, presently is equated with currently. Presently is not currently. And types.
But next, my
The
lord.
type is equated with types now. Anyway, forget that.
But at page 153 is their next. This is of 1988.
Yes.
At the bottom of the page could not have been a shape of goods because the application is at page 154. Next 155. Is the one 155.
That is also device.
This is also a device.
Yes.
And my lord will kindly see user detail 15/4/1945. They couldn't have been using a plastic bottle from 45. Next, my lord, page 156. Again, 5th of May 88, class 29, all edible oils. Now, my lord, will kindly look at it at page 157, the falsity of their case. My lord will kindly see at the top, the date of application is 5th of May 1988.
Yes.
And your lordship will kindly see the user detail proposed to be used. Now, my lord, page 158 is very interesting. Page 158, coconut oil, Shalimar such and such, who claims to be proprietors thereof and by whom the said mark is proposed to be used. And their predecessor in title, the said mark has been used continuously in respect of the said goods. How can it be? Shalimar might have been. Same at page 159.
No, we don't understand this argument. Shalimar Chemical Works is claiming that they have been using continuously.
Continuously since 1944. Whereas his application says proposed to be used. At page 157, my lord.
No, proposed to be used. I mean,
my lord, the date of application, your lordship looks at the date of application. 5/5/1988.
Very well.
Possibly they were not using this label in 1945, even in 1988. Now, page 160. 160 also, my lord. These are all labels, all device. 162, your lordship kindly comes. Different dates of user. No consistency, nothing. My lord will kindly see date of application 4/8/1997.
Now, why so many certificates?
Can I just clarify something? But page 158 does not relate to 157. It's a document of 1997, which relates to page 159. It does not relate to 157.
All right.
Similar mark
Yes,
used for
because
44.
157 is self-contained. The trademark
I'm
itself
sorry,
is
I
there.
stand corrected, my lord.
Image is there. You are right, Mr. Vach.
I stand corrected.
Yes.
My lord, page 160, again a label mark of 4th of August, 1997.
All relate to device. Everything,
All
whatever
relate
we
to
have
device.
till now.
All relate to. My lord, 162, your lordship kindly take.
Everything up to now, yes, we have gone up to page 170 something. So all device. If there is anything else, you can show us that. Apart from device. Up to 181, we find device.
My lord, kindly give.
Yes. But first, we have to ascertain the scope of the trademark.
Yes. My lord, 156 and 157 relates to the same. 156, your lordship will kindly see the mark trademark number 490519.
Yes, 519.
157 is 490519.
Yes, but 158 is different. That is what Mr. Vach was saying.
Okay. 158 different.
158 is completely different. 156 and 7, obviously, it's a continuation sort of.
Now, my lord, all this, my lord, right up to
device.
Device 162, your lordship will take.
Up
Device
to 181, probably device we have seen already.
164.
If there is anything else, you can.
Everything design. No.
If there is a departure, then you can.
Now, where.
No, Lord, please take. Lord, I'm sorry. Please take page 173 onwards. That's not strictly correct.
All right.
I'll come to that.
No, you said there's nothing more. All right.
No.
173.
173.
Yes.
This is he is claiming to be a shape of goods. Now, this application 1921095.
Lord, if your lordship would just turn the pages for the next 7
I
or 10 pages.
will assist your lordship. Page 173 with 175. It has been trademark type is device. It is device. It is not shape of goods.
I'm not saying anything. I'm saying they're there. That's all. The bottle is there in the registration.
First of, and claiming user from 1st of January 2004. Not a single document to show that they have used it from 2004.
Now, if in the trademark image the bottle is used, that does not mean that they have a trademark over the shape.
I will show the trademark manual.
No, you are right, because if they say device in the appropriate column in page 175, we are speaking of that. Even if the device appears in a particular bottle which is depicted in the trademark image, that does not give them a trademark over the shape. Definitely.
And my lord, they're pleading in paragraph 4 of the plain. I have been using plastic bottles from 1945 is also gone. Oh, my lord, same with page 179.
Up to the end, it's device.
It's all device. Nothing.
So they have got an injunction regarding trademark. Trademark, you cannot have anything to say.
Well, I will just.
Trade dress will look into that.
Oh, no, my lord, a very interesting thing. Page 184. I'm sorry, my lord. This I should have.
184.
Read with. The application number.
7429.
धारा 184.
Artistic work.
My lord, will at the bottom of the page.
Yes.
My lord, and the date your lordship will kindly see dated this 25th day of October 2010.
Right.
My lord, who claims to be proprietors thereof and by whom the mark is, or by whom, my lord, they have deleted this. Whom and their predecessors in title, the said mark has been continuously used since in respect of the goods. And now, my lord, will kindly see. Proposed to be used in present form, but Shalimar since 1945. The bottle was never manufactured. They have not shown any date of manufacture of this when they start using this bottle to succeed in passing off. And this is also proposed to be used. Proposed to be used in the present form.
They could not have.
So even in case of passing off, he has to give his date. That when has he started using it? And that he is a prior user. And this is of 2010. Dated this, the 25th day of October 2010. Even then it was proposed to be used. Excellent. Now, what documents do they rely for proof of user?
Mr. Bhattacharya, where was that pleading? Just give the paragraph number of the plaint where they say that we have been using these plastic bottles and metal since 45. Just give the you read it out, but
My lord, paragraph 4 at page 3.
Thank you.
No, I'm sorry. That is the application for dispensation. No.
Not that.
Paragraph 4. That's at page 48. HDPE means plastic.
Yes.
Polyethylene.
High density polyethylene. That's scientific name of plastic is that.
Poly?
High density poly.
Just do a Google search and tell us. Yes.
Now juniors are becoming clever. They are using
Ethylene.
ChatGPT
From ethyl.
and very dangerous. Judgments don't exist.
Yes. ChatGPT is much more dangerous.
Ethylene, ETH.
After poly, what? Spelling?
POLYETHYLENE.
Very good. Thank you.
Now, my lord, so far as to show user, what do they rely on? My lord, kindly takes volume 3.
Is there anything in your written objection or anywhere to regarding when since when plastic was introduced? I mean, we can go by your
plastic has been
general knowledge
before World War I.
Before
World War I. But
so we have to be sure on that.
Not.
Because you are arguing.
No, not on commercial use. Those were used for explosive.
But unless there is a pleading or anything on record to show that HTP was not existent in 1945, we cannot go by that.
They themselves have to establish. The onus is on them.
So they say that metal and HDPE was there. They have been using since 1945. That's a statement. You have to rebut that.
Yes, I've said.
Onus shifts on you to say that it was not there in existence.
My lord, page 184, your lordship will see. He says that I propose to be used in this particular form.
That's regarding. But you say that plastic was not in existence, not being used commercially since 1945. That is the repeated tenor of your argument. So you have to establish that. Somewhere there has to. Personally, we don't know when plastic was introduced.
Now, my lord,
Mr. Ghosh might have some idea when plastic. It appears from his expression.
Now, your lordship kindly takes
the
manual.
The manual means what manual?
No, manual of
not so sacrosanct that we are
trademark registry, my lord.
Oh, yes. একটা কপি ছিল না কিছু একটা দিয়েছিলেন part of this compilation? No.
Part of record.
The part of record.
No, definitely.
Manual of Trademarks, Practice and Procedure.
এই রে এটা পড়ে গেলে কিন্তু আপনি নিন আচ্ছা এটা আপনি এটা নিন আমি এটা নিন সেম আপনার কি এটা সুবিধা হলে এটা নিতে পারেন যেটা
যাচ্ছে না কেন এড্রপ অন করিস
ইয়েস
ভুলছে না and it kindly gives me a moment. He wants me to airdrop it and now it has এই বন্ধ করে এটা এই বন্ধ করছে না না yes now my lord kindly takes page 6 of this document my lord
page 6
4.1
yes
application must contain the following information name of the proprietors
sorry probably wrong
the page number would page 16 I'm sorry I'm page 16 my lord bottom of the page
yes 4 point right
page 16 my lord 4.1
right
application must contain the following information and this is apropos the sections whether the sections are quoted next to it
yes yes
name of the proprietor valid email id principal place of business address for service type of mark word label device in case of convention applications only single year now my lord 2 lines if your lordship skips to next page
yes
2 additional description of the trademark including whether it is a shape or a color trademark where is it in his applications
some of these applications are after coming into force of this act
now my lord 4.2 very important
yes
the representation of the trademark must clearly identify the trademark and should be in the prescribed manner as provided in the application form it should show clearly all the features of the trademark additionally in case of a trademark that consists of 3-dimensional well if it is a shape it has to be 3-dimensional or color combination it is necessary to make a statement to that effect in the applications the representation must be durable and satisfactory my lord the corresponding rules are also mentioned in the next column now your lordship kindly takes page 19
yes
my lord 4.7
right
in case of shape marks the applicant must state on the application form that the application is for shape trademark if this is not stated but it is fairly clear because the trademark has been depicted in a 3-dimensional drawings no 3-dimensional drawings they have not shown the examination should query whether or not the trademark is in fact a shape trademark now 4.7.2 the representation of a shape trademark or a trademark consisting of a shape should, wherever practicable, be in the form of a perspective drawing that shows clearly all the features of the trademark. The parts of configuration claimed to constitute the representation must be accompanied by a concise and accurate description of the trademark. Nothing done over here. This description will be entered as an endorsement of registration and will thereby serve to help define and scope of the registration. There should be no discrepancy between the representation and the description. Generally, the description should refer to the representation to make clear what the relationship between them is. Now, my lord, in case of color marks, Rule 29, my lord, 4.8 at page 20, of this. If the
Yes.
If Rule 29, if the applicant is claiming a combination of colors as applied to the goods or their packaging or as used in relation to their services as a trademark, they should claim that this identify the trademark as a color trademark. On the application form, the exact description of the color combination as per the International Classification System of Colors to be verified, as well as supplying a graphical representation of a trademark. The applicant must also provide a concise and accurate description of the trademark on the application. Even my lord, they have not claimed it for a color combination. And this is all there in the rules. If your lordship wants me to take me through the rules,
Need
my
not,
lord, the
because those have
2000
been referred.
the 2002 rules, I can take your lordship straight away from the 2002 rules, because now the rules have changed into 2013. My lord, will just.
Is there any particular rule regarding or manual, any provision in the manual regarding device trademarks?
No. Yes, my lord. It says whether it will be a device, label, or a mark. I will come to that. My lord, will kindly just for my satisfaction, your lordship will kindly see 29(2) of the 2002 Act of the 2002 rules. My lord, it confirms to 4.8.1.
Yes, the rules have been referred to there.
Yes, my lord, will kindly see 29.2. Whatever is stated in 4.8.1 is what is stated in.
Yes.
Now, my lord.
Yes. Right.
It kindly gives me a moment, my lord.
And not only that, one black and white and
no, my lord.
One reproduction, 29.2 says one reproduction in black and white and 4 in color.
Yes.
So that there is no doubt.
There is no doubt.
And they probably haven't asked for a 3-dimensional trademark also. That's not reflected in the application or the certificate.
Nothing. And I will show from the documents on record, my lord.
Is there anything in the rules regarding trade dress?
My lord, that's what it says. 4.1 at page 16.
Device.
Word label device. How device has been defined, my lord, that I will show from Narayanan, my lord. My lord, will kindly see page 16 of that manual.
Yes.
My lord, application must contain the following: name of address, type of trademark.
Word label or device?
So, 99, 2002 correct? Accept. my lord, will kindly also take the trademark rules 2002. My lord, will kindly take, there's a particular form which is given, which is form TM1. My lord, may I just pull it out for your lordship, my lord? Because the books which we have has now amended the. My lord, may I just take, take it and just take it? 2002 rules to have. 2002 rules to the ওখানেও আছে।
এখানে আছে, দেখে নিচ্ছি তাহলে।
So Bhattacharya, which rules were you showing?
Trademark rules 2002.
Trademark rules 2002.
Oh, 2002. I see.
Because their registrations are prior to 2015 manual, my lord. 2017 rule.
We have trademark rules 2017.
Yes. But
their registration was of 2015.
2010, 2015.
Yes, prior to that. That's why you are right. So that's why those are not here.
The rules are. Yes, after copy, lordship. That is the form 1, my lord. TM form 1.
Trademark rules 2002 এই বইটা না, এটা আরো মোটা তো। এটা 2016 এর এডিশন, 2016 এডিশন, 2022 এটা কারেন্ট। আমরা তো কারেন্ট চাই, ওই জন্য কারেন্ট দিয়েছি। কারেন্টই তো লাগে। টু রুলস এখন কোথা থেকে জোগাড় করবো?
My lord will kindly take another copy, my lord. My lord, your lordship, does your lordship has it? I'll just stand up, my lord, your lordship.
এটা আপনি নিন, আমি একটা নিই।
Your lordship will find form TM1.
TMA1 or TM1?
TM1. Form TM1.
Yes.
My lord, to be filed in triplicate accompanied by 5 additional representations, such and such, 1 representation. I will skip out. Now, my lord, to the registrar of trademarks. The registrar's direction, the lordship has found just below the form. To the registrar of trademarks, the office of.
Form TM1 টা দাঁড়ান, wait a minute. Yes.
The registrar's direction may be obtained if the class of goods is not known. Specify the goods or services for the class in respect of which application is made. A separate sheet detailing the goods and services. A specification of the goods or services should not exceed such and such as express an excess space fee of 100 characters. The applicant should state the exact number or excess characters where specification of goods or services exceeds 500 characters. Insert legibly the full name, description, occupation, calling, and nationality. In the case of body corporate or firm, country of incorporation, and the partners composing. My lord, these are not important. Now, my lord, 4, the applicant should state the address of his principal place of business in India, if any. See Rule 3 and 13. If the applicant carries on business for which registration is sought at only one place in India, such fact should be stated. And as a matter of fact, their initial registrations were restricted to few states: West Bengal, Odisha, Bihar, and all these eastern states. Should be stated and the address of the place given. If the applicant carries on business of goods or services at more places than one in India, the applicant shall state such fact. And
why are you placing this, Mr. Bhattacharya? For what purpose?
My lord, for the purpose of color, your lordship has asked me.
Yes.
For the purpose of color.
And there is something interesting.
My lord, 9. If your lordship kindly looks at 9.
Yes.
If color combination is claimed, clearly indicate it and state the color. If the application is in respect of 3-dimensional mark, statement to that effect. It was there in the rules. Serial number 9.
And in your this trademark manual also, 4.3 at page 17, this is requirement of graphical representation, even if
Yes.
it's not in 3D.
Yes.
It requires that each trademark consisting of or containing colors, shape, or packaging must also be accompanied by a concise and accurate description of the trademark.
Man.
So it has to be stated there are 3 coconut trees of brown color, maybe that. There is no description, we don't find any description of that sort in that.
In any of their applications.
Or this.
Rather, they have disclaimed. The category of the mark, they are saying device. And what is device now? My lord, now I have to go back to Narayana. Now, my lord, for the purpose of completeness, I'll just show, my lord, color marks 4.8, which is at page 20. Because this has been derived from the rules.
Yes.
Because an argument was made by them that this is a draft rules. That this is a draft manual. But what has been derived is from the statute itself, because the corresponding provision has been given next to it. If the applicant is claiming a combination of colors as applied to goods or their packaging or as used in relation to their services as a trademark, they should claim this by identifying the trademark as a color trademark on the application form. The exact description of the color combination as per International Classification System of Colors to be verified, as well as supplying a graphical representation of the trademark. But as I said about smell marks, so this has posed a problem to the trademark. How do you graphically represent a fragrance? That is the obstacle. That is the obstacle. That is the obstacle. Why fragrance marks are not being registered in India?
No, a separate category can be put for that. If 3D has been incorporated, then why not fragrance itself is a category? Maybe the chemical composition,
that
maybe
is
something of that sort, some genre.
Something.
There are several ways to identify smell, even chemically.
This conundrum, my lord, has been going on for a while, and maybe I do not know what the ministry is doing about it.
Should be done something. It is not so tough as it appears.
As well, my lord, all indicate that fragrance marks cannot be graphically represented, and that is the
How can you graphically represent a fragrance?
It can't.
Cannot.
But that's the requirement of the act, that it has to be graphically.
You cannot have a smell, have a trademark on a smell in India. You cannot have under the present law. How can you have it? I mean,
it cannot. As well as supplying a graphical representation of the trademark, the applicant must also provide a concise and accurate description of the trademark on the application. The description, which should state precisely what the mark consists of and how the description relates to the representation, will be entered as an endorsement of registration and will thereby help define the scope of registration. As example of a suitable form of description for a trademark which consists of a combination of color applied to pharmaceutical this is the query which was posed by your lordship, what it would mean.
Exactly.
The trademark consists of maroon color applied to one half of a capsule at the end.
That is what we are saying, yes. That 3 coconut teas of brown color and beneath that something like that.
Yes, the trademark consists of a maroon color applied to one half of a capsule at the end and a gold color applied to the other half, as illustrated in the representation of the application. Where is it? In the present case, where is it? Now, my lord, the last.
Roughly speaking, Mr. Bhattacharya, a device can be represented in a stencil or a dice.
Yes.
Basically speaking, there can be letters in it, there can be pictures in it, but it can be represented by a stencil or a dice.
Yes.
Roughly speaking, I mean, this is just from common sense. A device should be represented. It can come in a dice,
a label or a signature,
whatever. I mean, you can have a seal of that.
Now that's why all the celebrities like Shah Rukh Khan and all, they get their signatures registered as trademarks.
Oh, do they? I didn't know that.
Yes, Shah Rukh Khan signature is registered. because now the act has included signatures.
My knowledge goes up to Lata Mangeshkar's voice. After that, I have lost touch.
My lord, your lordships, well, ground reality is everyone's signature is trademark. No one can copy
Yeah.
it. That would be forgery.
Right, that would be forgery. Not passing off, but forgery. Worst.
My lord, kindly comes to 12.2.6. No, but they use it for economic
No,
purposes.
we understand. That
So
is
the
just
purpose of registration is
Yes,
to
yes,
use it for
obviously.
economic purposes.
And fashion design and fashion labels are, I mean, they use those in, and also lines of, in the hospitality business and other businesses also.
That's
Clothing and all.
not for the sake of just having it registered so that
You can try
companies
having
won't-
your signature trademark.
nobody will copy it.
Let us see. I mean, we
Nobody will
don't- never
copy it.
know.
I can't say something.
You can engage people for copying it so that it gets popularized.
Mr.
They
Chaudhary.
pay people so that they
Mr. Chaudhary has a story, but that cannot be
Sir,
discussed.
Which Mr.
Vishnu Chaudhary.
Vishnu Chaudhary. He has a story on that also.
Yes. That cannot be.
I will happily copy Mr. Abhijit Mitra's signature or trademark.
Look,
if he gives me his checkbook, very happily.
Let us not discuss that on camera. Yes.
My lord, 12.2.6 at page 65. If your lordship kindly come.
We are still on the manual.
Yes.
Yes.
Under section 3. Under section 3, a mark is not registrable as a trademark.
Section 9.3.
9.3.
Yes.
If it consists exclusively of the shape of good which results from the nature of the goods themselves, or the shape of goods which is necessary to obtain a technical result. Like the ribs of a hot water bag. The effect is actually to transmit that, hey, my lord, to reduce the pain.
It's too generic. I mean, if you have a trademark on
the
that,
shape which gives substantial value to goods. It provides an explanation which reads as, for the purpose of this section, the nature of the goods or services in relation to which the trademark is used or proposed to be used shall not be a ground for refusal of registration. Now, shape of goods. A distinctive shape of goods or its packaging or any three-dimensional object capable of being represented graphically can be a trademark. And application for registration of the same can be filed. However, the trademark shall not be registered if it consists exclusively of the shape which results from the nature of the goods which is necessary to obtain technical result, or the shape of goods which gives substantial value. My lord, and this has been dealt with. My lord, will kindly come to the next page, something which gives, my lord, this has been explained, shape necessary to obtain technical result.
Yes.
The subclause prohibits registration as a trademark where the shape of goods is necessary to obtain a technical result. In this connection, this subsection must be interpreted to mean that the mark consists exclusively of shape of a product is not registrable by virtue thereof if it is established that the essential features of that shape are attributable only to the technical result. This does not automatically mean that the shape is not registrable even when all features serve some functional purpose. It can be shown that an essential feature, which may include the overall impact arising from the way the individual features are arranged, is not only attributable to a technical result. The shape is not one which would be adopted for its functional efficiency. It will not be caught by 9.3b. Shapes which do not consist exclusively of functional features attributable only to the technical result will be open to objections under 9.3b. Marks in this category are deemed to be incapable of acquiring a distinctive character, and therefore the filing of evidence will not overcome the objection. The subsection deals with shapes which add substantial value to the goods disregarding the main function attributable to a trademark, source identification function. While the legal test for distinctiveness is the same for shape marks, but it has to be distinctive. Like I gave the example of a contour bottle of Coca-Cola. What distinctiveness lies in this shape? Disregarding the main function attributable to a trademark source identification function, while the legal test for distinctiveness is the same for shape of goods as other marks. So it has to be distinctive. He has to prove why it is distinctive and how it has become distinctive. The figures which he has given is the turnover of Shalimar, which includes all these 5 bottles, but not of this particular shape of goods. Without that, can he prove his distinctiveness? And can he succeed in even in an action of passing off? Even if I accept he is a prior adopter, which adds substantial value disregarding the main source. While the test for distinctiveness is same for shape marks or for other marks, recognition must be given to the differing perceptions of the average consumer in relation to non-traditional trademark. In particular, the average consumer may not as readily accept the appearance of the goods themselves as indication of trade origin. But because when I said somebody, I've said, as Miss Lala told me, she says, I tell my man Friday, go and get me parachute and narcolete. It is known by the brand. To qualify as a shape mark, the test is much higher. The test has to be much higher. Otherwise, when we send this kind of products, we say get Shalimar and narcolete. Relating to non-traditional trademarks, in particular, average consumer may not easily accept the appearance of the goods themselves as an indication of trade origin. This is because average consumers are not in the habit of making assumptions about the origin of products on the basis of their shape or the shape of their packaging in the absence of any graphic or word element. Here, my lord, the graphic element and the word element is Shalimar this, KMP this. The more closely the shape for which registration is sought resembles the shape most likely to be taken by the product in question, the greater likelihood of shape being devoid of distinctive character. It does not have any distinctive character whatsoever. The shape of packaging is to be treated as shape of goods themselves, and goods are trade and package form for reasons associated with the nature of the goods, for example, beverages, cleaning fluids, etc. For example, my lord, the Harpic one. But here, my lord, look at all their Shopkota bottle. Yes. And I've shown, my lord. Sorry, what a chobita লাগিয়েছিল. My lord, will kindly look at the green change করে দেবো, ওটা হলুদ করে দেবো, কোনো ব্যাপার না. My lord, page 716, kindly look at this.
Volume 4.
Volume 4. How many? Plastic jar, coconut tin, this, that.
Yes.
They cannot claim monopoly over shape. And now, my lord will also, since your lordship is on that volume, my lord will kindly take page 708. I will start from 707.
You are done with the manual, Mr.
Yes,
so we'll return this. Yeah, on it. আপনার তো রাখতে পারেন ওটা। এটা ভেঙে গেলে মুশকিল। হ্যাঁ, কপি লাগবে, হ্যাঁ, না হলে হবে না। Mr. Bhattacharya, please just supply copies of the manual later on. One copy is already there with.
Also, my lord, I will have to give the rules.
Yes, before the hearing is over. Yes.
Rules 2002.
Please just take the trouble of reading.
And the 1958 Act also, the difference in
that will be very helpful for us. Yes. Page 709.
By 707, if your lordship kindly.
707, right.
So Mr. Chandra was the applicant himself. He did the due diligence. He went to the trademark site.
Yes.
Your lordship will find. Now, trademark, category of trademarks, your lordship will find tick marked. He has chosen a word mark. Now, my lord, kindly comes to page 708. Your lordship will find,
Yes.
your lordship will find a drop box. Color, device, shape of goods, sound marks. My lord, as a matter of fact, the first sound mark which was registered was Nokia.
Oh, is that?
Yes.
That's right.
That shaking of hands, that was the first sound mark which was registered in India. Sound marks, three-dimensional word. So what has he chosen? Device.
Yes.
TMA, not TMO. That requirement also there. They could have a detail.
He has chosen this word. No, what is the difference between the previous page and this? Previous was the application.
Application.
You can apply for category of mark in Word and then choose device.
Yes.
All these things.
Then
Because
you can change
word, my lord, word is like Bisleri.
It's a drop down menu. When
but there's in the drop down box also there is word. There is an option.
Yes.
But you can go to this drop box by applying for a word trademark.
What a word also. Word, color, device, shape of
So
goods.
he applied from page 707. It's evident that the application for category of mark,
that Mr. Chandra chose.
Mr. Chandra chose word, and this is also Mr. Chandra's application itself. Next page 708. When he chose word,
what he has done is he has taken the drop box down to demonstrate under what categories a trademark can be registered.
He chose word. That's why this has come.
Yes.
No, this preceded. Page 707 preceded.
This is preceded.
So you can apply for word, but then have an option of going to other things.
No. Either you apply for a color combination. My lord, kindly
He
see
applied
color.
in the category of word.
He applied
page
in the
07.
category of word.
This came first, page 707.
No, this will not come first.
This will not come. This will come second.
That is what we are asking. So you chose word and then this came.
Right. Now, my lord, the definition of device, as you fell from your lordship, এটা photocopy করে জজসাহেবকে দিতে হবে, না হলে এটা হবে না. My lord, may I do something? May I come back, my lord, and do this photocopies because I have to read it out and it is important for your lordship to see this. My lord,
What are those?
My lord, the definition of device, trade dress, trademark, all is there. My lord, this needs to be photocopied.
What is that's a book? I mean,
That's a book. That's a book.
Please take out photocopies and just.
That's it.
এই বইটা আনিও না যেটা লাইব্রেরি থেকে. If you can give the reference of the book, can you get it in the
It's
shop?
Narayanan on trademarks, 6th edition, my lord.
Give the book once to our officer. We'll just take down the book and
I will also cite that Gips Lemon's case. I know Mr. Bachawat will butcher me, because there are paragraphs which goes against me. But what kind of shape marks can actually be registered? I will.
বইটা একটু নামটা একটু ইয়ে করুন.
Lord, I'm a practicing vegetarian, so Mr. Bhattacharya says.
I'll show why SRM.
Whether you consider Mr. Bhattacharya as vegetarian or non-vegetarian.
In Chambers, he was forced to be vegetarian, but I know he stays
Outside, you
far
know
away
this.
from all things vegetarian. But not
Most probably we won't be able to get it, so you get photocopies also. We have full confidence in our library, so please get photocopies also.
My lord will be surprised to see. Today I showed to Mr. Ghosh, Atish Ghosh. The lordship will go to the Bombay High Court website.
Yes.
Even handwritten orders of 1865
are there
in the archives, including all judgments passed by Bombay High Court.
Mr. Bhattacharya, we are not even getting space, manpower, leave alone manpower. The posts are not being created. We are not getting space despite, hitting our heads against the wall. No space is being given for digitization.
This we have come to know during our arbitrations. And how is it different from here to there?
Not only from there, from many other places.
During
Don't get the funding even.
During conversation with him, we have learned.
Yes, he would be able to tell. I mean, you have to go out with begging bowls to the authorities. So even then, we are not given the funds,
As a matter
and we
of
get the funds. We get the funds suppose on 29th of March, 29th of March, and we have to spend it by 31st of March. So it is like that. So it's very difficult. Otherwise, we have grand plans, we have vision, everything is there.
That's all
Apart
there.
from the funds and the space.
But I went to Delhi High Court. None of the lawyers had any books or papers. Even the judges did not have any papers. It was a giant screen.
It's not a very tough task to achieve, provided you have the minimum funds.
Yes.
And you have the goodwill also. We have the goodwill now. Now the present generation has the goodwill. But other things are there, Mr. Bhattacharya. Let us see. I mean, this liquid test we have been trying, some of us from since long. So it's not yet there. We don't have even funds to get handhelds. Anyway, let us not compare ourselves with other courts. So let us stick to our own. Not guns. If not guns, pistols. So you get photocopies, then we'll continue on the next day, next Tuesday. Then very good.
But should it be tomorrow?
No, assigned matters are taken up on Tuesdays only. This is an assigned matter. Is it an assigned matter? Yes, it is an. So we'll take it up on Tuesdays. So hard in part for further hearing on July 15, 2025.
Grateful.
Thank you.
দেখি তুই কতখানি বলতে দিস
আমি তো আসবোই he's saying that let me see how long you can allow me to continue. I said I will not come.
That is why Mr. Rudraman Bhattacharya not can get butchered by. That is a non-vegetarian who will
actually.
Yes. এটা নিয়ে না থ্যাংক ইউ এটা স্টেপল করে একটু ওই এইটার সঙ্গে রাখবে জ্যাকেটের উপরে তাহলে রাখাটা আইডেন্টিফাই করে ওইটা প্রতিদিনই লাগবে
জাজমেন্ট তো দেখাতে হবে
থ্যাংক ইউ ইয়েস
গ্রেটফুল
নেক্সট
Item number 11.
You're appearing, both of you?
Yes, my lord.
Yes.
Time for the appellate.
Yes.
Yes. What has the food safety officer done?
My lord, I'll just summarize it.
Yes.
My lord, I have a leader in the matter. If your lordship may consider condoning the delay, my lord, in the meantime.
You're being very clinical. What is the delay, Mr.
My lord, 47 days. It's
Count?
within the period but not permissible in the Act. Act says appeal within 60 days.
Mr. Bose is there. Yes. 60 days. So why have you taken out a condonation application then?
60 plus 60. Statutory period is 60 days. Then period to condone the delays are for the period of 60.
What is the reason? Just tell us.
Well, one of the principal reason is that the legal officer had some personal difficulty. Thereafter, the department. There is no code apparently in the computer section for a statutory appeal from this, the Prevention of Food Adulteration Act. So eventually, department suggested that you file it as a FAT. Like usually customs appeal or custer appeal. So there is no separate computer code.
But it's not a decree. It should have been an FMAT then. Anyway,
this is what the department suggested. Because it's a statutory appeal.
Even if it's a statutory appeal, it's against an order. First, FAT is only for first appeals against decrees. Should have been classified properly. We can direct it to be classified properly, but then it requires a formal admission. Section 5, let us dispose of first.
My lord.
And then we'll... Oh, no. Then that order will not be tagged with the main.
My lord, one indulgence, my lord. My lord,
Yes.
in the cause list, lordship mentioned a defective, my lord. Whether, my lord, the defect for the delay, my lord, because
We will just check up. You could have checked up before.
Delay, there's a defect.
Section 72 of that act, civil court has no jurisdiction.
No, of course, the appeal lies before the High Court. That's
No,
what
the department says that the stamp reporter report says that it might have been wrongly classified as FAT.
Okay.
Because yes,
Should have
the
been a
stamp reporter's
FMAT.
report is right.
Correct.
Instead, CRA it says. Let us check up which one.
CRA.
FAT or CRA. What CRA we don't know.
CRA I thought was
One defect is you have not given the name of the presiding officer. That you can incorporate. I mean, you can ascertain and incorporate. In the preamble of the
we are in
memorandum.
appeal from the order of the appellate tribunal.
No, that is the second authority.
Yes.
So then the preamble has to be corrected further. You have to say, I mean, order dated such and such, thereby affirming or reversing the order of the first authority. You have to put that in the preamble, Mr. Bose. That has to be incorporated.
In the memorandum.
TRA was CRA টা কি আবার?
Well, if your lordship looks at the memo,
দেখি একবার ক্রিমিনাল ইয়েতে since it's a punishable offense, that is the order, so they are saying that it should be classified as a criminal appeal.
Criminal appeal.
Yes.
Okay, lordship will see.
Statutory appeal.
No, the criminality under the act.
Yes.
Lordship will kindly have a look at give 2 copies of the act.
In terms of the sections of the act itself.
Yes.
Criminal appeal. Criminal appeal. What jurisdiction আছে? Criminal appeal কে নিচ্ছে এখন?
Well, there are different sections, there are different types of order. Our order is restricted to, my lord, there are two aspects of it. One is substandard and one is misbranding. My lord, we are aggrieved by the, my lord, misbranding part. I succeeded before the adjudicating officer, which was the first authority.
It's an offense under the statute. So there's a criminal element. That's why probably the officers, the stamp reporter has penal provision রয়েছে কিন্তু তার জন্য criminal appeal হবে because 340 previous 340
yes,
those appeal 341 appeals were classified as criminal appeals, although it's in the criminal procedure code itself.
Yes, well, there are certain offenses.
Definitely not a first appeal.
No, definitely not a first message. It has to be either it will be a miscellaneous appeal or a criminal appeal.
Yes.
Where is the provision for penalty?
5152. Section 51, section.
Yes.
We'll give you 1 week's time.
My
You
lord.
please carry out the corrections in the preamble.
Very
We'll
well.
send the matter down to the office and direct it to declassify appropriately.
Very well.
In the meantime, we'll have a talk with the departmental people to ascertain which should be the correct classification. We'll keep it vague in our order. We'll just send down the file and direct it to come back after a week.
We will also try and
We'll give
convince
you
the department.
Yes, you also you'll just have an interaction with the department. You can have that, and we'll also try to ascertain whether it should be a criminal appeal. We'll just ascertain whether what happens if there are orders of criminal nature which are not under the criminal procedure code or IPC.
Well, your lordship can take into consideration 2 sections, 51 and 52.
51 and 52 are the sections. Yes, we have seen that.
Yes.
Those contemplate penal provisions.
Yes, it does, my lord.
So
Penalty.
we'll just have a talk with the listing section how these appeals against orders of a penal nature arising out of other statutes, how they are classified. I mean, whether as a criminal appeal, because it is not arising out of the IPC or the now the BSS or the PNSS. So how they are classified.
Very good.
If there is a specific class of classification for those orders, then we'll direct it to be categorized as CRA.
Otherwise,
Otherwise,
miscellaneous
FMET. Yes.
FMET.
But
Very
either way, if we pass an order on the Section 5 application, we suppose what the difficulty in the age of digitization is that this order won't be tagged with the main, because it will be a different number then. The people who work at the ground level, they will be knowing.
So we'll come back after a week.
Come back after a week. Leave is granted to the learned advocate on record for the appellant to carry out the necessary correction in the preamble of the memorandum of appeal by inserting the name of the appropriate presiding officers of the forums, the orders of which have been challenged here, as well as to insert the particulars of the order passed by the first forum. What we will do is, you will just say either affirming or reversing order number such and such of the first forum, like the second appeals.
Like the usual.
Like the second appeals. And give the names of the presiding officers of both the forums.
Absolutely.
And second, as rightly pointed out by the stamp reporter, since the appeal does not arise out of a regular decree passed by a civil court, the classification of the same as first appeal is erroneous, full stop. Accordingly, let the appeal be classified appropriately, full stop. For such purpose, let the file be sent down to the department. Full stop. Such rectifications and appropriate reclassification shall be carried out within a week from date. The matter shall be listed next on July 15, 2025 under the same heading. Now the correction in this FAT, you have an interaction with the department. What they say, আপনি একটু ডিপার্টমেন্টের লোককে এই ক্রিমিনাল সেকশনের লোক কাউকে আজকেই বিকেলে আমার সঙ্গে চেম্বারে দেখা করতে হবে।
Criminal
And there's a provision which contemplates setting up of a special court.
Yes.
And there's a public prosecutor in case of injury or death of a consumer.
That's a different thing.
No. So the criminality part, there is separate, appears that under section 74, there's a special court set up for that.
No, that's a different aspect altogether. Now, appeals before this court, I mean, the High Court,
yes,
against orders which are of a penal nature,
yes,
like say what example, the Electricity Act contains some such provisions. 135 is there.
Yes, yes.
Previous 340 of the CRPC, that is under CRPC. CRPC, IPC,
yes, that's what I'm saying. So those part of the Electricity Act which like theft, those are tried separately by a criminal court. They go under the courts under the CRPC. But here, there is a special court which has been set up under section 74 to try offences under this act.
Yes, but that's a different concept. 51, 52.
So it's like customs
KMC Act
excise.
51, 52. KMC Act গুলো কি সেটা তো মিউনিসিপাল ম্যাটার হিসেবে ক্রিমিনাল হিসেবে হচ্ছে। ওটা কি ক্রিমিনাল হিসেবে দেখে?
Well, kindly once take, well, just for your lordship, kindly take one section 71, subsection 6.
Yes.
subsection 6.
341 criminal appeal হিসেবে কিন্তু হতো। CRPC 341 71, yes.
Subsection 6.
6.
Any person aggrieved by any decision or order of the tribunal may file an appeal to the High Court within 60 days from the date of communication of the decision of the order of the tribunal or term. So, I have invoked this provision.
There is no doubt on that.
Yes.
High Court is the court, but the classification. We are only on the classification.
No, on that criminality part. So,
this is irrespective of criminality.
Yes, but that is which will go under which, whether it will be criminal appeal or miscellaneous appeal.
That was what we were wondering also, because there can be separate types. Some have civil consequences, some have criminal consequences.
Noted.
If you direct that it will be classified as criminal, then under the same act, under the same provision, there will be two categories of appeals. You are right on that. The appeal provision is this. apart from 51, 52, there are other civil consequences provisions also which are applicable before this.
There are.
There are sections
Yes,
which
yes,
provide.
yes, yes.
So those are also applicable.
Yes.
Then if you direct it to be registered as a criminal appeal, then there will be two classes of appeals from the same, under the same provision.
Under the same.
That's why we were thinking about miscellaneous appeal.
We'll ascertain and come back.
Yes.
Great.
And we'll do our part also in the meantime. We'll have a talk with it. Yes.
Item number 12.
এই ফাইলটা একবার একটু পাঠিয়ে আজকেই পাঠিয়ে দেবেন বিকেলে। এটা কি assigned?
Well, this is a 37 appeal. But now, my lord, it has to be admitted under Order 41, Rule 11. My lord, we had preferred the appeal before the 37 court, taking up arbitration matters.
Right.
This is a preliminary objection which was taken by my learned friend that even a 37 appeal has to be admitted under Order 41, Rule 11.
That has been upheld.
Upheld with a observation of the Honorable Division being that the matter, the rules have to be amended. But that is not important. But now we are before your Lordship, my lord, for admission and hearing of the. This is the last order by the earlier division. Order nahi hai, correct?
Yes, we have it here.
Yes, yes.
Anyway.
Paragraph 6 is the final observation.
Now the entire matter has been assigned to us.
It also been assigned.
Yeah, we are admitting it and hearing the hearing.
There is an application also, my lord.
Application for?
Application for stay.
What is the nature of the order?
My lord, not,
the award?
It is an order. My lord, I'll tell you, Lordship.
Oh,
Suit filed by my learned friend, impleading Murshidabad Jila Parishad as one defendant and another party as another defendant.
Section 8 from Section
8. And the order is a composite order. Section 8 is first taken up. My Section 8 application is taken up and dismissed. And then his Order 39 Rule 1 and 2 has also been allowed. So, my lord, there is another separate appeal.
Yes, has to be.
Yes, I have filed a separate appeal.
Rightly.
From that part of the order by which
that appeal is pending before some other court.
For your lawsuit. It is before
Both
your
have been
lordship.
assigned to
Now
us. Otherwise, it would be very difficult.
So it will be a regular appeal before your lordship.
No, that appeal is not appearing before us.
When I am giving the number.
Give the number, we'll put it together. Yes, next week.
Let me sub copy of this.
Yes, it's sub whatever.
I have only filed a memo of appeal because, my lord, actually one of the sections.
Same. The other papers are the same.
Yes, all papers.
All the relevant papers are annexed here.
No.
Yes. Subject to correction.
What other papers? You supply the give copies to
but the issue
them?
is only very short. Whether the subject matter of the suit is covered by the arbitration agreement.
Mr. Tewari, we have to look into the plaint, the
Yes,
Section 8 application, objection, and the contract must be annexed somewhere.
Yes,
in the Section 8, it has to be there.
Yes.
So
Some other documents which is not annexed, my lord, I'll supply that.
Is it necessary?
other documents can we look
Other
into?
documents means, my lord, suppose, my lord, section objection to the Section 8 applications.
Oh, yes, those are.
No.
Oh,
There are other documents, my lord, which are used in the trial code, my lord, which are not
Yes,
annexed.
which are there in the trial code, everything has to be.
Yes, that is
Very
important.
well.
Objection to Section 8.
Let both the matters be heard together.
We are, what is the number of the other?
Appeal number.
Just give on a slip of paper and
FMA 162. FMAT.
FMAT 162.
Now,
FMAT or FMA?
FMAT. This is an appeal challenging the order of.
Correct.
Huh?
FMAT.
It has to be correct to the T.
Yes. But I have still not been able to enter into the merits. Last so many days, I was trying to.
No, we'll ensure that you can enter. if you are here next week. I mean. Otherwise,
Yes.
everything remains whatever else. We are apprised that the present appeal arises out of an order passed on an application under Section 8 of the Arbitration and Conciliation Act 1996. Footstop. By the self-same order, an order was also passed under Order 39 Rules 1 and 2 of the Code of Civil Procedure, against which a separate appeal has been preferred. Footstop. Accordingly, the other appeal bearing FMAT number be listed along with the present appeal under the same heading on July 15, 2025. Footstop. in view of appearance, you are appearing for all the respondents.
No, no. Respondent number 1 and 2.
All the respondents are represented
Yes,
before
yes,
us.
yes. All the respondents.
Who is not appearing? Which respondent? We are not interested in you alone.
Yes, no, all 1 and 2 and 3.
Since all the parties are represented before us, comma, service of notice of the appeals is dispensed with, full stop. There is a section, there is no section 5.
No.
We are formally admitting this appeal. And the other appeal will admit and take up. Dispensed with, full stop. In the event, the pleadings before us have omitted any relevant document which was a part of the trial court records at the time of passing of the impugned order, comma, the respondent number 1 shall supply those upon furnishing prior copies to the learned advocate on record for the appellant and the respondent number 2,
Respondent
comma,
3.
respondent number 3 on the returnable date. Full stop. Next para. In view of questions of arguable questions on fact and law being involved in the appeal, comma, we hereby admit FMA 816 of 2025 to be heard on the grounds as taken in the memorandum of appeal.
Well, it is understood that the appeal and the application will be disposed of together.
Yes. We could now
We can memo.
we stopped short of doing that because we have not yet admitted the other appeal. So we'll do that on the next day.
And
Please
only
come
one
prepared, all
thing.
of you. No, you are appealing for 1 on the in the last order it is recorded. You are for 1, he is for 2.
Wrongly recorded. 1 and 2. I am appearing for
1 and 2 and 3.
3.
Well, in the website, there are 2 numbers. One is the filing number, one is the registration number. Which is the number? I have given the filing number. There is the registration number 167.
No, registration number.
তাহলে 167 হবে ওটা।
Registration number.
What is the filing number?
I do not know, my lord. Here there is a
Filing
filing
number
number.
initially given, subsequently once it is regularized, then registration number is given.
No, FMAT becomes FMA.
No. It is a FMAT stage. Initially,
What is the nature of the file registration number? It's not like FMAT.
No, it is just
initially, my lord, filing number is given. There
You
are
will give an example of a filing number? What is it?
162.
162.
Or forget that.
ওটা 167
167.
FMAT 167 তাই ওনাকে দিন উনি লিখে দিন
167
পরে ধরতে পারবো তাহলে
একটা এই মেমোর কপিটা দিন
হ্যাঁ
আমি আজকেই তো
হ্যাঁ
কবে রাখো lordship is kept it on
15th. We take up assigned matters on Tuesdays.
Yes. Huh?
Item number 13.
My lord, I am
Yes.
acting on behalf of the respondent, my lord.
Right?
The appellant is not here, perhaps.
Who is not here?
The appellant.
Oh, you are for the respondent.
I am for the respondent, my lord.
Probably they won't be anticipating it will be taken up now. What is the application for?
The appellant, it's for substitution petition application. One
Just adjourn for the day.
appellant has died, as well as the respondent number 1 is died, my lord.
Acha.
I'm for that.
Application is filed within time or beyond time?
That, my lord,
One is expunging the name of respondent number 1.
my lord,
So heirs are already on record.
on record.
Acha, very well.
I am respondent, I am on behalf of the respondent, my lord.
So you are appearing for the heirs.
Respondent number 1 is dead, died,
2 is for substitution on death of appellant number 1 and 2 both.
my lord.
Is it filed within time? Let us just check it. No, delay is there.
Delay is there.
They did not mention the delay. রয়েছে? Part of places due to occupational reasons outside the state. আচ্ছা, ঠিক আছে।
Delay
কতটা ডিলে দেখিনি, কবে মারা গেছে একটু দেখে নিন। একজন মারা গেছে 11ই মে 2023, আরেকজন 24। Have you got copies of both the applications?
My lord.
Is there any serious objection to Can 2? Check up.
Not at all.
Can 2 is
There is no serious such objection, my lord. Can 2.
Can 2 is
Can 2
for
is for
substitution of appellant
substitution.
1 and 2.
1 and 2.
Do you have any serious objection?
No, my lord.
We are allowing both. Inform your They advocate for the appellant. Although none appears for the appellants, comma, the respondents are represented through counsel. For sub next para, in view of the innocuous nature of the prayers made in the in Can 2 of 2024 and Can 3 of 2025, comma, we take up the applications for being adjudicated in the absence of the appellants. For sub next para, Can 3 of 2025 is an application for expunction of the name of respondent number 1, whose heirs are already on record. For sub next para, since the application is otherwise is in form and the contents, the averments thereof are not opposed by learned counsel for the respondents, comma, Can 3 of 2025 is allowed, comma, thereby recording the death of respondent number 1 and directing the name of the respondent number 1 to be deleted from the cause title of the memorandum of appeal.
My lord.
Full stop, there will be no arrest to cost. The necessary corrections shall be carried out by the learned advocate for the appellant within a week from date. Please just inform the appellant. Can 2 of 2024 is an application for substitution of the heirs and legal representatives of the deceased appellant numbers 1 and 2 upon setting aside abatement on condonation of delay. Full stop. We find from the averments made in the application that sufficient reasons for the delay in preferring the application has been made out, particularly in paragraph number 7 of the application, to the effect that the heirs and legal representatives of the deceased appellant number 2 resides elsewhere and were not aware of the particulars of the case. First up, next para. Accordingly, Can 2 of 2024 is allowed, comma, thereby directing the heirs and legal representatives of the deceased appellant numbers 1 and 2, comma, as mentioned in the cause title of the present application, comma, to be substituted in place and stead of the said deceased appellant numbers 1 and 2 upon setting aside abatement on condonation of delay in making the present application. Full stop. The necessary rectifications in that regard in the memorandum of appeal shall be carried out by the learned advocate on record for the appellants within a week from date. What is Can 1? Can 1 is on merits.
Merits, man. No.
That will take up when they come.
Section 5.
Can 1 is section 5. What is the delay? Let us see.
Section 5, my lord.
Section 5, yes.
Can 1.
What is the appeal against?
It's a partition suit, my lord.
Preliminary degree?
No.
Final degree. What is the delay in preferring the appeal?
They have failed to establish their title in respect of the whole of the property.
So suit has been dismissed.
Partially decreed.
So they are the plaintiffs.
Plaintiffs.
So they have come up against the portion which has not been decreed. Yes, we are condoning the delay also.
Yeah.
Octogenarian.
151 days.
151 days, yes. Taking care of mother, octogenarian.
As well as COVID.
Etc. Yes, we are allowing.
Everything is.
No, should we wait for them to come?
Because
We don't understand your gesture. Yes or no?
otherwise, we are, my lord, we are not opposing, but still, my lord, since
Very
they are
well.
not there.
Let Can 1 of 2021 be listed for hearing on July 14, 2025.
Otherwise, it will go to wrong signal.
Right, you are right. Yeah, you get your point. But please inform them that that they have to correct the cost title of the memorandum.
That's all.
Oh, thank you.
Item number 14.
None appears at the time of call. Let the matter stand adjourned for the day.
Item number 15.
15 I am for the applicant.
Yes.
My partition shoot, my client is plaintiff. Preliminary degree first.
You are challenging the preliminary degree?
My client not challenge. The defendant challenge before this honorable court.
You are the respondent?
I am for the respondent.
This is your application?
My application. Honorable court directed.
Are they enjoying any interim order?
Yes, my lord.
What have they challenged? Preliminary degree?
Preliminary degree.
What is the interim order? The usual order?
Not to pass final degree.
The usual order.
Paragraph 12 and 13.
No, they have put in special messenger cost.
Paper book, my lord.
Have they put in special messenger cost?
I do not know, my lord, nothing has
Give a
been done.
notice to the other side. Give a copy of this application to the other side so that they also appear.
They must-
If they have already prepared paperbooks, why do you take the trouble?
My lord, I search in the department till date no paperwork is ready.
Records have come.
Record come.
Are you sure?
My clerk said my record has
No, ascertain first. Give a notice to the other side and come back. A copy of the application be served. The appellant shall serve a copy of this application on the learned advocate for the respondents and file a receipt in that regard on the returnable date. Let the matter stand adjourned till July 14, 2025.
Good.
You also take information in the meantime whether notice of appeal has been served on them. Because if notice has not been served, they cannot be castigated for not preparing the paperbooks.
Item number 16.
Please give your whoever is appearing with you and your name. Yes.
Item number 16.
15, 16. Yes.
My lord, not today. Mr.
Can't hear you. Use the microphone, ma'am.
Not today, my lord. Mr. Mitunjoy Haldar is not well today.
Mr.
Mitunjoy Haldar.
On the prayer of the appellant, let the matter stand adjourned for the day.
Item number 17.
Yes.
May it please, your lordships, I am appearing for the petitioner in the matter.
Yes.
Defendant number 2.
I oppose this application. My
My lords, would you please to recall this is only, my lord, for that extension of time, my lord, to file, my lord, the opposition to the injunction petition before the, my lord, learned trial court, which we have done. My lord, we have affirmed it, we have served it on the other side within the time frame given by your lordships. My lord, it has been on the record of the learned court. But my lord, since it was beyond time that, my lord, it was filed, my lord, we are seeking for an extension, a formal extension, my lord, so that the my lord, opposition is kept on records when the matter is, my lord, heard out.
May I file my affidavit?
My lord,
Here I have of my care application.
No, what is the impugned order? Let us see the impugned order first.
there is no impugned order, my lord. This is an appeal which was filed by my learned friends.
All right,
My lord,
right.
after that, the appeal was disposed of with a direction, my lord,
Yes,
on
Mr.
us that
Chaudhary,
we
why
have to
shouldn't you?
find them.
Why shouldn't you extend it?
Yes, ma'am.
It was affirmed in time, served in time.
No, none. They say it was affirmed in time, but the affirmance itself will demonstrate that it was not.
What was the time given? Let us see that first.
My lord, well, my lord's judgment,
Yes.
my lord had given 3 weeks time from the 3rd of March and
All right.
directed as expeditious disposal as possible.
So by 24th March.
And my lord had come to the findings, recorded that fraud has been committed and whatever. And what happened thereafter, knowing, and I will have to say this, because knowing that the suit was out of their control, because the deed has to be set aside, they went and managed the plaintiff number 2, who, on the basis of the decision of the board of Shabites, had been representing the plaintiff number 1 till that date. She was managed. She didn't even communicate the order.
She means Shopna Mukherjee.
Shopna didn't even communicate this order to the trial court. It was I who, coming to know of this, had to apply. Me who, being Shopna's sister, another trustee, another Shabite.
You are also parties here.
No.
No, my lord. That is the precise point, my lord. Kindly permit me to remind your lordship. My learned senior friend has been addressing this matter ad nauseum, even at the stage when my lord was pleased to call for short affidavits. May I just inform the honorable court that he is not a party to this litigation. He has been airdropping himself, my lord, in proceedings both before the trial court as well as
Mr.
before this
Chaudhary,
honorable
unless you are a party to the in the trial court, how can
He
you
cannot
permit
be
to-
heard saying things.
What is your locus standi to
His
address
advocate
us?
on records, Wakalatnama has been recalled.
Yes, Mr. Banerjee, you get your point. Let him answer that. Yes.
My lord.
The party is the deity.
Hmm.
I am not seeking to represent the plaintiff number 2. I am seeking to represent the plaintiff number 1.
Can you segregate the plaintiff like that?
I am not.
Then you have to be added in the suit.
My lord, I have already applied under Order 1, Rule 10 to be brought on record as a co-plaintiff.
You were not a party when this order was passed. So what
When
is your
this
locus?
order was passed, my lord will kindly take annexure K to the plaintiff. Over page number. She filed the suit on the basis of the authority given by me, which is a part of the plaint. I have
All
now
right.
withdrawn that authority and I have chosen to appear myself.
But post facto you have withdrawn after this order.
After this order,
So
yes.
they are seeking a modification of the order. We have to look at on that date.
Very well. I'm not going into the
Regarding
facts.
this, we won't be
I'm
hearing.
going into the facts. My lord will kindly see
We'll
what
record your submission. That
my lord has
yes.
not hurt me. My lord, the submission is what they did. They say that they affirmed it in time, but they did not file it because it would have got lost if it was filed on an off date, and they were advised to file it on the next date when the matter was taken up. The next 3 orders thereafter, the matter was taken up. I was heard in extenso on the application because Shopna refused to move the application.
Absolutely incorrect submissions are being
Mr.
made.
Banerjee, you cannot comment in between.
Let me finish. The order records so. The order records so.
Will be saved in a minute, so we'll take it up tomorrow. So you can carry on for 1 minute, Mr. You exhaust yourself today so that you half the steam is lost on the next one.
3 dates.
He'll come back rejuvenated, man.
Yes, Mr.
Actually, I will. 3 dates, the matter was taken up. There was no whisper that we have used an affidavit in opposition. It is there. My arguments start and proceed. Then, when they found that Shopna, that even though they had managed Shopna, the others had stepped in and they would not get a clean goal, then they realized that they would need to file an affidavit in opposition. My lord knows it is not very difficult to get an affidavit affirmed on a backdate before a notary. It's not before the oath commissioner.
What is he saying?
And I say so with authority. So then what happens? They do this. Then they serve. Who do they serve? They shop. Even though they know I was appearing, the order records. So they go and serve Shopna behind my back.
But you are not yet a party to the suit. Why should they serve?
My lord.
You are definitely entitled to move your application for addition.
My lord, very well. Forget whether I'm a party or not. I'm going to bring certain records, facts to the notice of the court.
Bring to the notice of the suit court. We are not concerned. This is a very limited
for the purpose of extension. For the purpose of extension, I'm going to bring certain facts to notice of the court. If after hearing this,
appoint him amicus curiae, my lord.
If after hearing this, my lord, and very well, if he wants an authority,
don't respond to him.
If he wants an authority, whether I'm entitled to represent or not, very well, I'll go into judgments.
So we'll come back tomorrow.
I'll come back
Hard in part for further hearing.
My lord, may we have leave to file the reply, my lord? My learned junior is carrying it, my lord.
No. You had that leave. On the last occasion, there was a direction.
Yes, but maybe
So
we will
ready
file
with the
it.
reply.
We are ready, my lord.
Yes, file it. Definitely over there. Say that.
Our application there is no.
My lord will kindly, my lord will remember.
You have filed this opposition as a composite opposition to 3 and 4.
Two, because I was only able to manage to get copies
Can
of
3 and
2.
can 4.
Yes, I've only 5 have not been served in spite of asking for a copy. I was not.
Why?
Served by post.
Very well.
Served by hand right now. Served by post. What is CAN 5? CAN 5 is for?
Same thing, same friendliest extension.
Another party.
Another party.
These two are basically identical applications, even though by different parties, the reply is similar word to word. They have not dealt with any of the allegations. They stand admitted. They've only said that the court should not hear me. That's the only thing in the reply. The allegations of fact stand admitted.
Please appoint him an amicus curiae, my lord.
In opposition to CAN 3 of 2025 and CAN 4 of 2025, as well as the replies thereto. Only one reply. Two parties have filed reply.
I've been served with 2 replies.
Yes.
But I haven't got a copy of the other application.
And the affidavits in reply thereto filed today be kept on record. Full stop. A copy of CAN 5 of 2025 shall be served on the learned advocate on record for the
my left for say Mr. Chaudhary stand that will do.
You're not even a party.
Huh?
You're not even a party.
I don't need to be a party. I've got judgment this
But
I
the
don't need to be
proposed
a party.
interveners during the course of the day.
Yes. I don't need to be a party.
No.
Lord, let this service be without prejudice, my lord, that he can't open his mouth, Lord. Let this service be without prejudice. We are not accepting.
What has given me leave to open my mouth and to file an affidavit?
Otherwise, my lord, appoint him an amicus curiae, my lord, so that we can be enlightened. No difficulty.
Amicus curiae or amicus fury? What do you mean?
Fury, my lord. Up to now, it has been pure fury.
Transforms to fury.
Actus fury.
Deeply obliged, my lords.
দিয়ে দাও দাদাকে দিয়ে দাও